Adjournment request, if any, from item number 1 to 4. From item number 5 to 15.
Make it, your lordship.
Yes.
May I have your lordship indulgence to mention item number 39?
39. You have asked for 5 to 15.
No. 5 to 15, adjournment
15,
request, 5 to 15.
I heard it.
May I please, your lordship, with respect to item number 6,
Yes.
lordship, I am paying for an adjournment in this matter.
Have you informed the other side?
Lordship, we are for the department, no, other side has not appeared, lordship. In this
Or
matter,
is this for the first time?
for the first time, for
All right. Why do you want time?
lordship, my senior, Mr. SCKL, is in the Itanagar bench, lordship.
All right. What time do you want?
Lordship, 1 week,
As great for 1 week, we have fixed many cases in 1 week. We keep it 2 weeks.
lordship.
As great for on behalf of the petitioner / Commissioner of CSGT and Excise, CGST and Excise, re-notify on so and so date.
13-8.
Much obliged, lordship.
Please, your lordship. I beg to mention item number 9, my lord.
Yes,
I am for the respondents, my lord.
yes,
Senior counsel, Mr. K. Chaudhary is out of station, my lord. So I'm praying for a short accommodation. my lord.
that's right. Then you have you informed the state of Assam?
Yes, yes. I have obtained the consent, my lord.
The land council for the respondent seeks an adjournment because of the unavailability of the advocate who is to address this spot. Stop. A consent has been taken from the appellant state. Re-notify 2 weeks.
I'm obliged, my lord.
18-8. From item number 16 to 29, adjournment requests.
May I please, my lord? My lord, with respect to item number 20 to 24, my lord, departmental,
24.
my lord, departmental instructions have been received, my lord. I'm praying for 1 week time to file our affidavit, my lord.
Can't hear you.
We have received our instructions, my lord. Departmental instructions have been received, my lord. We need some time to file our affidavit, my lord.
Coming from
Somebody would like to mention only. Yes,
My lords, may I mention, my lords?
which item?
Item number 55, my lords.
No, you have to wait for your turn.
Very well, my lords. My
Just wait
apologies.
for your turn, but remain on the wings. Somebody else is mentioning. All right, yes.
Very well, my lords. My apologies.
Item number 20 to 24, my lord.
Yes,
We have received our departmental instructions, my lord. I'm praying for 1 week.
you
time
are
to
for
file-
state of Assam.
My lord, Finance and Taxation Department, my lord.
That's right, and 2 others. So you're the respondent.
My lord.
All right. Have you informed the other side?
Yes, my lord.
Okay. The taxation department seeks some time to put in the written response. The consent of the appellant has already.
When you hear that, it's time for me to mention.
Re-notify after 3 weeks.
28. Next.
My lord.
May I please, your lordship, my lord, I beg to mention item number 27, my.
Yes,
My lord, I pray for 1 week adjournment, my.
you are for the appellant.
I am for that,
You want 1 week's adjournment
my lord.
as prayed for on behalf of the appellant. Re-notify. All right.
I do apologize.
11-8.
May it please your lordship, I'd like to mention item number 28, your lordship.
Yes,
Due to some personal difficulties of Mr. D. Sharma, your lordship, and the matter be adjourned for 2 weeks, your lordship. We'll file an affidavit in the
Courtroom is
reply.
vacant, so you may
I
sit in
find that
the
not
courtroom and make a
on
bench.
the ground of personal difficulty of the council who is to address the court. A prayer for adjournment has been made. Re-notify on so and so date.
13-8.
Oblige, your lordship.
Adjournment request from item number 30 to 42.
May it please, your lordship. Lordship, we have circulated an adjournment request on behalf of item number 34, your lordship.
34.
34, your.
Yes, you see that.
Lordship, my senior is currently out of station. He's before the Itanagar bench. Lordship, may I seek for a date, your lordship, to be fixed later?
What time? How many weeks?
Lordship, may it be fixed on a particular date, your lordship.
You tell us how many weeks you want, the date would be fixed by him.
Indeed, lordship, 2 weeks.
2 weeks, as prayed for on behalf of the petitioner. Re-notify on so and so date.
13-8.
Much.
May I have your lordship indulgence to mention item number 39?
Yes,
Here, my lord, we are to file one affidavit in reply against the affidavit filed on behalf of respondent. But
you appear for whom?
I am the petitioner. my
You are the petitioner. You have to file rejoinder affidavit.
lord. So 1 week time maybe.
But
sufficient.
I don't think the National Commission for Indian System of Medicine has filed any reply affidavit?
It has been filed, my lord, on 26.
My noting says that reply has been filed already. All right. A prayer for adjournment has been made on behalf of the petitioner for filing a rejoinder to the counter affidavit filed on behalf of the respondents. Re-notify on so and so day. 2 weeks?
13/8.
Wait, your lordship. Lordship, I actually, I thought 31 lordship. Here I am here item 31 lordship.
Yes.
I am for the appellant lordship. So where I have taken consent from the department council lordship. Lordship, can it be taken after 1 week lordship?
Have you informed
Yes, lordship, I have taken consent from the department.
as prayed for on behalf of the respondent state, re-notify 2 weeks?
13/8.
Wait, please, Lord. Lord, I'd like to mention item number 36 of today's list, my lords. As per the last order, my lords, we were required to file an affidavit. I am for the petitioner, my lords. The petitioner is out of station, my lords. Can I pray that this matter will be taken up after 18th of this month so that I can?
As prayed for, you have 2 weeks.
Yes. 28.
Oblige.
From item number
No,
40.
just somebody was mentioning online. Yes.
My lords, I wanted to mention item 55, my lords.
Yes.
I had appeared on the last date at the interim stage.
Yes.
I was only requesting, my lords, if it could be on a date, my lords, when I would be able to come, subject to my lord's convenience, to argue the matter out, my lords.
I would be here always. You tell us your convenience.
My lords, would it be possible to do it on the 13th or the 14th of August or the 27th of August, my lords?
27th of August suits for me.
I'm most grateful, my lords.
As prayed for on behalf of the parties, re-notify on 27 under the same heading. All of you.
Most grateful, my lords.
Your lordship, in the same matter, there were 4 other appeals which were tagged along with it. Writ appeal 89 to 92 of 2025. Those could also be listed.
All those tagged matters shall remain listed, shall be
On the
there
same day.
same day.
Oblige, your
Number.
Give the numbers.
Yes, the order has it. You'll just hand it over.
Any other request?
May it please your lordship, I beg to mention item number 11, lordship.
Where were you all this file?
Lordship,
Yes, what do you want?
due to some personal difficulties, my senior could not come today. He has also submitted the
You appeared for whom?
petitioner.
Okay, appellant.
Yes, lord.
What do you want?
Finally, pass over the matter for the day, lordship.
Passover.
Fix the date, your lordship.
Passover tomorrow. Passover is tomorrow.
Oblige.
My lord, in item number 59, that has filed and rejoined today, my lord. Can it be called, my lord? We have already filed. 59, 59, supplementary.
Where is the supplementary? I don't know. Maybe single page. Anyway, 59. Okay, what does he want? You want an adjournment?
No, my lord. We have filed an affidavit, my lord, today morning, my lord. Can it be called?
In the morning.
Yes.
Therefore, another date has to be fixed. You don't expect the registry to be so prompt.
But
Huh?
my lord, other side may be raise of
The affidavit, if the affidavit is not on record, we will have it posted on another day. Let's see, let the case be called up.
Yes, let the question.
Any other request? No. Daily list for orders, item 1.
Please, your lordship, I beg to appear through VC, your lordship.
Yes.
Well, there's an I in this matter. The main matter concerns supply of drinking water to in the
Yes.
city of Guwahati.
Yes.
And the matter has been pending for some time. What compelled us to file this particular IA, my lord, IA 3242, your lordship, is that while the matter was pending, a report had come from the Comptroller and Auditor General, my lord, highlighting numerous irregularities, my lord, in the implementation of the project. My lord, work was not done, payments were made, interest was paid in violation of the contract, my lord, and there were various issues pertaining to non-implementation of various critical components of the project, my lord. Therefore, your lordships were pleased to call for a reply from them, my lord, on 20th of January 25. Then they took further time on 4th of March 2025, your lordship.
Yes.
Well, the issue is urgent and important, my lord.
Mr. AG, where is the report of the CAG?
AG's report we have received and we have received a response also. We have prepared the affidavit, some clarification we are asking. That clarification has not come. That's why the affidavit could not be filed. But otherwise, we are going to file it in very short time.
File it shortly
Lord.
for the reason that there has been already great delay.
The delay is regarding Lordship, the implementation of the projects.
Yeah,
There are
that's
three
right.
projects.
That's right.
Two projects already done and the third project, Lordship, it is not going to start immediately. We are very categorical because the first financial bank who was supposed to support, they have
That's all right. So what do you have to say about South Central and North Guwahati water supply projects?
South.
South Central and North Guwahati.
This is, it is, at some stage, it is already functioning. So far
You'll
as
have
this
to-
South Central Guwahati, in April, it was to be functioning fully. Lordship, the up-to-date report was that when we filed the last affidavit, it is going to be functioning. And in the other, Lordship,
That's all right. So Mr. Saikia, we'll like
now
to
the
have-
problem is not functioning. The problem is that there is acute shortage of customers. Wherever we have started, people are not taking connection. That is the problem now.
Lord,
That
may
is
I
because-
respond to your lordship's query?
And you're charging very.
No, it is
dearly
not
for water.
charging because everybody has a deep tube well or existing GMC water supply. So that is much cheaper in comparison to this. Here the commercial rates are definitely very high, but not the residential house. This is the new challenge we are facing, Lordship.
Yes, Mr. Petitioner, what do you have to say to this?
Just to respond to your lordship's query regarding the South Central and North, they had given a affidavit of May 2023, your lordship, where they said that the commission would happen for South Central and South,
No,
South Central and North by December of
Mr. Fulton,
2024.
before that,
My lord.
we would like you to respond to this factual scenario
My lord.
where there are no good number of customers because of the cost
My lord,
involved in taking water supply.
My lord, my response to this would be, my lord, that this is resulting in depletion of the groundwater table, my lord. And
That's
this is a
different thing
very, very,
altogether.
this
That's
is a very,
different
very,
thing altogether. That issue can be flagged in some other petition, but here you had come perhaps for a direction, a mandamus to the authorities for providing water supply, potable water to all these citizens.
my
right?
lord, my lord.
And something has been done, and now there is some reluctance on the part of the customers, the end users, for the cost.
You know,
Now,
this
what
is
is to be-
something
what is
that
to
has
be done?
come for the, this is something that has come for the first time, my lord. This numerous
And,
affidavits were filed, but this was never stated earlier. In fact, they were reassuring the court time and again that
Therefore-
you know, the
So
project would be
therefore,
complete.
the correct step would be to ask Mr. Saikia to put in the CAG report. We'll see what has happened.
CAG report is already there, my lord. I have filed it with my
The
eye.
response we have to.
Ocha,
It's
the
not
response,
because
the response of the state and the difficulties faced by them for completing the project or for commissioning it.
It is already commissioning, Lordship, but we are not getting the adequate number of customers now.
Continue.
If I may just
My lord,
point out, my lord, these projects were,
That is the problem.
my lord, if I may just point out, these
Maybe
projects,
we have to revisit the charges or something we have, or maybe we have to start a drive to stop all those underground boring facilities which the
Can you-
individual
can you do
houses are
that?
doing.
Can you do that? That's the whole difficulty.
That is
For that
because
we'll
it
have
is
to
against public interest, but so far as law is concerned, Lordship, the Groundwater Act is there, then there are a lot of regulations. That is a central government authority,
We'll see what is to be done.
Lordship.
Let's.
my lord,
But
may I
Mr.
just request for a specific date so that, my lord, I can be there physically, my lord?
Heard Mr. A. Fukan, learned advocate for the petitioner, and the learned advocate general Asana. In this PIL, an attempt was made to seek a mandamus against the government for providing drinking water through water pipes, which hitherto had remained unregulated, leading to indiscriminate extraction of groundwater. Efforts appear to have been made, and some of the projects were completed also. Mr. Advocate General informs this court, has informed this court that some of the projects have been commissioned, but the customers / citizens are not ready to switch over to the supply of water through connected pipes. Most of the residents under the jurisdiction of the Metropolitan Council, under the jurisdiction of the, what is the body here?
GMC, municipal.
Metropolitan Authority
Development Authority.
have their own source of recovering water, recovering groundwater for the purposes of drinking. See, the water pipe connection would entail initial costs as also the running cost. Precisely for this reluctance on the part of the citizens in accepting potable water through pipes under the projects, the projects have not started. The projects in some cases have not kick-started to the satisfaction of anybody. The issue requires further determination by the state to ensure that groundwater is not indiscriminately extracted, or it would lead to many other complications in the natural system. The response of the state on the CAG report ought to be filed by the next date.
Lord.
Re-notify so and so. 2 weeks we give you, Mr.
Lordship.
Lord, may I request if it can be on 11th or 12th, subject to convenience?
Is it possible? 12th. 12th.
Deeply obliged, my lord.
Highly obliged.
Item number 2.
May it please your lordship. May it please your lordship.
Yes.
Service is incomplete, lordship, as per office note 1907, lordship.
It's pending.
Have you taken steps for?
Yes, we have taken steps, lordship. If
Awaiting
required,
the
we'll
service
take
report.
step,
All right. Respond number 1 and 2.
lordship.
It's taken on February 2020.
We'll give one more time. Awaiting the service report. In respect of notice issued to response number 1 and 2. The matter is adjourned to give 3 weeks. Thereafter, we'll see what is to be done.
Lordship. Oblige, your lordship.
28. Item number 3.
What is happening?
Some steps taken way back on 2022. But
Nobody.
no answer.
Delay of how many days?
36 days, my lord. You have otherwise condoned the delay, but I don't know the practice here. I condone
This is generally condone the delay. But
only in the presence of the other side.
generally, but
Oh.
when it's the other side is paid, then
The respondents have not yet been served. Awaiting the service of notice and the compliance report on them, the matter is adjourned to. We give it 2 weeks.
18.8.
We'll see on that.
Finished. If they don't appear,
Item 4.
Oblige.
May please your lordship.
Yes,
There is a delay of 91 days. Today itself I'll take steps, my lord, during the course of the day, my lord.
you have taken steps only today.
Today, my lord, during the course of the day.
Is it within the time?
Yes, ma'am.
Is it within the time given to you by the court?
No, my lord.
You were
somehow, my
supposed to
lord-
take steps within a week.
Yes, my lord. My apologize for that, my lord. Somehow it's late, my lord.
Okay.
Today,
The land
during the good.
The land council for the applicant submits that steps have been taken for service of notice on the respondents, though belatedly. Let that be accepted as valid deposit of requisites for notices to be issued. The notices be issued as directed by order dated 9/5/2025. Returnable on date after 4 weeks.
Must come, must.
27/8. Item number 5.
I'm sorry, my lord, I am wearing the high cover, my lord. No, my lord, this is a IA under section 5 of the limitation act for condoning 4 days delay in filing the accompanying appeal, my lord.
Without issuing notice to the other side, we deem it appropriate to condone the delay of 4 days in preparing this appeal. For the reasons stated in the application.
Paragraph 5.
The delay is condoned, the application stands allowed. The registry to register the appeal.
Possible.
For admission, item 7.
We have a different system.
Yeah, but appeal is not before, but in the corona, all together, together.
Yes, who appears?
And it changed in that background.
3, 5 and 6.
Nobody appears on behalf. We don't discuss it, no? Appeals we don't discuss. Nobody appears on behalf of the appellant. Counsel for the respondents are present.
Same. All one.
And he was called twice. I think he's not interested.
Eviction and eviction is already carried out.
Oh,
Right, like.
oh. It appears from the records that the appellant has not been appearing on successive dates. He perhaps has lost interest in the matter. We therefore dismiss this petition, dismiss this appeal for want of prosecution.
Item number 8.
Also, kindly examine the method for 1 week, Lordship.
You should have asked for it in the beginning, no?
Lordship, because in the course list, Lordship, the respondent's name is not reflected, Lordship.
What happened?
In the course list, respondent's side advocate's name is not reflected, Lordship.
How does it concern you now for addressing the court? Anyway, what do you want?
Lordship, 2 weeks, Lordship.
As prayed for on behalf of the appellant to be notified.
13/8.
Obliged, Lordship.
Item number 10.
Yeah, but the appeal has been prepared, Lordship, against the order dated 5/8/24, passed by the Honorable single bench. Lordship will find the impound order page 70, by which the prayer of the petitioner was partly allowed, although the order of cancellation from service of the petitioner was set aside, and he was directed to reinstate it. But the regularization of the service of the petitioner was not interfered with, my lord. So my grievance is that, my lord, since it is held that the cancellation of the order was illegal, because it was passed without serving any notice and providing any opportunity of hearing to the petitioner, and no shock was noting, nothing, my lord. And very arbitrarily, the service of the petitioner was cancelled by the authority, my lord. Although
It's Correct order. Yes, who appears for the state for the BTC? Who appears for BTC? He is standing up.
Musari was the planner.
Yes, what do you have to say to this?
So earlier, R.K. Masari was appeared also in this case also.
You were sitting somewhere in the corner, you are not responding.
Lordship, I am very
Gentlemen,
sorry,
advocate.
Lordship. I was not aware about this matter, Lord.
What else do you want? Mr. Counsel,
Lordship.
are you continuing in the job?
Yes, my lord. Now I've been appointed on temporary basis on my earlier post, my lord.
Nothing can be done.
But my lord, my prayer is that since the termination was illegal from my post, and the regulation of service was done by the authority after following the procedure, my lord. And only on a complaint of by third party, an inquiry was made, and it is held that the inquiry report, your lordship will find page 46.
Look at this, inquiry report is not questioned here. Pursuant to the inquiry report, your services were terminated, but without issuing you any notice.
Yes, my lord.
The court has interfered with it. And court says that you may not be regularized, but you shall be in service. I think the court has given you every relief that you are entitled to. Your regularization was not no process was followed. And therefore, rightly, it was not done overnight or on stealth or in stealth. Where there was an inquiry, an administrative inquiry, which found that your regularization was not correct. You would not be the only one, there would be many others.
Lordship, but
The only consideration which a court had to take into account was that you are not rendered remediless, number one, and number two, your job is retained, and that you don't come to the stage of destitution.
lordship, that is that part, my lord.
We don't think you have a case any further. Take them. We have heard Sri S. Nath, learned advocate for the appellant, and Mrs. R.B. Bora for the Bodoland Territorial Council, bracket BTC, Kokrajhar. The records reveal that the appellant was initially engaged on a contractual basis as a tax collector in the Bijni Municipal Board during the year 2016-17. Subsequently, he was formally appointed on a regular basis with effect from 2019. Thereafter, the appellant claims to have served the council diligently in that position. His services were regularized also from 1/3/2020 pursuant to a resolution passed by the Bijni Municipal Board on 25/2/2020. However, later, sometimes in February 2022, the Urban Development Department of Bodoland Territorial Council, bracket BTC, Kokrajhar, issued a notification directing the Joint Director of Town and Country Planning Department, who also serve as Council Head of the Urban Development Department, to conduct an inquiry into the legality of the appointments of several posts, including that of the tax collector, junior engineer, LDA, and others in different municipal boards. In the inquiry, it was found that the regularization of the appellant and others was not after following any procedure. And therefore, the report of the inquiry dated 6/7/2022 held such regularization to be bad. Relying on such report of the inquiry, relying on such inquiry report, the services of the appellant was terminated with immediate effect, that is from 16/2/2023. The appellant was never noticed, nor was provided any opportunity to show his cause. The learned single judge who heard the matter did not agree with the decision of the BTC to terminate the services of the appellant on various grounds, but primarily on the ground of the appellant not having been noticed and given an opportunity to explain his cause. As such, the learned single judge directed the counsel to reinstate the appellant in service. However, cautiously, the learned single judge refrained himself from not awarding any back wages for the period in question. The further direction / observation of the learned single judge in this circumstance was that the appellant must be considered fairly along with others for his appointment. Mr. Nath, learned advocate, submits that the appellant is now working on a temporary post, perhaps on the initial post on which he was appointed. As and when vacancy would arise, the council would take necessary decision in formalizing the services of the appellant. Nonetheless, not finding any merit in not finding any fault with the judgment of the learned single judge, we have no option but to dismiss this appeal. The appeal stands dismissed. Published.
Item 12.
Yes.
Petitioner is aggrieved in pursuant to a proceeding drawn under 14 of the Services Act. Now, petitioner purchased a plot of land that on the basis of an NOC provided by the bank, page 31, my lord.
That's true. But never noticed. Surface is there. But he's contesting the way. That's right. But then he is contesting way. So therefore, the prayer would be that the 14 proceedings be stayed till the OA is decided. That's reasonable. That is reasonable. That even Bajrang, what is that judgment? Who appears for the bank?
Notice yet to be issued, my lord.
Who appears for the bank?
Notice yet to be issued, my lord.
Notice will
My lord.
All right. The petitioner seeks protection with respect to his property in Jorhat. Stop. The land in question was purchased by him in the year 2019 from respondent number 4 / Manik Chandra Datta. After obtaining a valid no objection certificate from the respondent Punjab and Sindh Bank, the no objection certificate of the bank clearly permitted the sale of the property. The sale was preceded by taking all clearances from the Deputy Commissioner Jorhat. And thereafter, the possession of the property was taken. Later, the bank proceeded against the erstwhile owner of the property / respondent number 4 before the Debt Recovery Tribunal, Guwahati, for the purposes of recovery of the loan. It was the same property which was purchased by the petitioner. The petitioner alleges that he was never noticed in the proceeding under Section 14 of the SARFAESI Act 2002. And such omission to notice him as he, after the sale, becomes the owner of the property is very critical. No proceeding can continue, it has been argued, in the absence of the current owner who is in possession of the property and which property was purchased after receiving no objection from the bank. There is an apprehension of immediate attachment. Therefore, a prayer has been made in this writ petition to stay the consequences under Section 14 till the final outcome of the OA 159 of 2023 preferred by the petitioner before the DRT. The petitioner has also filed a title suit. The bank would require to be noticed. The respondent number 3 / bank would be required to be noticed. Let notice be issued to the bank on steps being taken by the appellant within a period of 2 days.
My lord.
In the period of 2 days, we give you 1 more day. Within the period of 3 days, returnable on short day. 2 weeks. The bank authorities are also permitted to be served dusty
My lord.
with a compliance with information to the registry by the petitioner about such service of notice.
Obligation.
13.
Lordship, in the order, it would be, as a scholar, it means the OA has been filed by him, the OA is filed by the bank.
OA has been filed by the bank. Oh, sorry, OA, till the disposal of OA. You're appealing for bank. You're
No,
appealing for the state. What do you have to say to this?
Paragraph 5 of his application, my learned friend's application, he says he's contesting this matter in the DRT. Paragraph 5 of his, on his own.
DRT, he may contest, but what about his rights? He was not noticed.
Indeed,
The
madam.
proceedings, I
He
mean,
was,
if
he
it
should have
is,
been.
that stands vitiated on that account,
Yes.
no? And the bank knew of it.
And accepted money.
Yes, my lord.
Yes.
Obligation.
Item 13.
We are not saying it now. We'll only hear the bank and then pass it on. When did you extend the
Pardon?
benefit of MACP to the,
Only from 2016, Lord. That will, Lordship will find at
only
page
from 2016?
84.
Why was it not brought to the notice of the tribunal?
Paragraph 4 of my, our
Now, let's
counter
see,
affidavit.
let's see the impugned order. Has it been discussed here?
Page 70, Lordship, we have stated, page 70,
17.
70, Lordship.
70 is what?
Preliminary objection, page, para number 4. This has not been, this paragraph has not been considered, Lord. And the notification, Lordship will find at page 84. By which the MSCP has been brought applicable to Defense Security Corps Services.
Your
Because
ASG,
Lordship, no, I'm not the SG, Lordship. I'm CGC, Lordship.
CGC. Okay. Notice has been issued.
First day, Lordship, notices.
All right. By the writ petition, the Union of India challenges the order dated 6/4/2023 passed by the Armed Forces Tribunal Guwahati Bench in OA number 21 of 2021, whereby the respondent's application was allowed and he was directed to be considered for grant of financial upgradation under the MACP scheme, under the modified assured career progression scheme to the rank of Havaldar, effective from 1/1/2016. Mr. Chakravarti, learned counsel appearing for the Union of India, has pointed out that the respondent had joined the Indian Army as a sepoy in the year 1978 and had served for about 17 years. Whereafter he retired in the year 1995. On his retirement, he was granted service pension in the time scale of a Nayak. 3 years later, he secured an appointment. He joined the Defense Security Corps, a second employment for retired army personnel. His services, his engagement was later extended twice, and he remained part of the Defense Security Corps till 2015. Till 2017.
17. He was supposed to serve till 2017, but he took voluntary retirement in.
He would have remained part of the Defense Corps till 2017, but he chose to take an exit from the service on 31/5/2015. His request for being paid, his request for allowing his entitlement under the MACP scheme was rejected by the concerned government, whereafter he approached the Armed Forces Tribunal. The tribunal, it has been argued, allowed the prayer of the respondent without taking into account that the Ministry of Defense policy allowing the benefit of MACP to DSC personnel was extended only in the year 2018.
With effect from 1/1/16.
18 with effect from 1/1/2016. The date before which the respondent had quit his service, had exited from the service. Let notice be issued to the respondent on steps being taken by the appellant/union within a period of 2 weeks, both modes returnable on You have 6 weeks.
Lordship, I have prepared for stay, Lordship.
In the
Stand up.
meantime, in the meantime, the operation of the order passed by the tribunal shall remain in abeyance.
Deeply obliged.
6 on 6.
8-9. Item 14.
Yes,
Lord, here also, the DRT refused to condone the delay of 24 days. In the connected matter, Lordship issued notice on Friday, the same order,
same order.
same party.
You have give the order, give a copy of the order,
Yeah, yeah,
same order.
same. Order. Only case
Oh,
number
last
will be
minute,
different.
yes, same order.
Did-
Again, it is not understandable to us. Why not appeal? Yes, same order.
Then again, it will go to the
Item 15.
Yes,
Lordship, this is claim of disability pension, Lordship. We have rejected on the ground that it is not aggravated to the service. Similar case of Lordship, some of the case already been listed today, item number 41 too. Same order.
similar. Or the sheet that's released paper.
same order, no.
And that's from 41 to 54.
You do it. Okay. Upload data. Same order, all right. Mr. Court, give it to me. Very fast.
Deeply obliged.
Take the Caesar. Just have the record on them. Some of the orders shall be yours.
Yes, it is.
Item 16.
One shot that comes. 60 or 50.
Maybe the Lordship.
Oh, no. It's 60 or 59. 60. 60. 60. 160.
Yes.
Lordship, this is a writ appeal, Lordship. Now, Lordship, the appellant is actually the wife of a deceased workman, Lordship. Sutku Burman, Lordship. He was employed as a Maksaral worker in 1981. After that, he was employed against the sanctioned vacant post, Lordship, from 1996. Now, Lordship, there was a scheme by the government of Assam for regularization of workers.
Your name did not find there, and your husband never did anything for it.
No, Lordship, he actually made a representation.
The representation is nothing unless you pursue it. And if the representation is not being decided, you have to come to the courts. I mean, the court will not take notice of people who sit over their rights.
No, but Lordship, the
Or what to do? You were not there. See, a distinction can be made with respect to work charge and casual employees.
Lordship.
But then that distinction also doesn't apply to, you know.
No, Lordship, but he was working as a sanctioned vacant post, Lordship.
Maybe, but it was not formalized. I mean, the government will definitely contest it.
But Lordship, the thing is that it was because of the negligence of a few government employees, Lordship, that his name was not reflected. It was not because of his own fault. He made a representation, Lordship, and they also sent it to the higher authorities, Lordship. And they accepted in the affidavit in the opposition, Lordship. Page 85, Lordship. Paragraph 6. With regard to statements made
Just a
in
minute.
No.
Who appears for the state?
Mr. Nayak.
He's here. Mr. Naik,
Yes, Lord.
truth is that his services, her husband's services were not regularized.
Yes,
But then there are other documents which indicate that there was a mistake. Communications were made.
Lordship. Yes, Lordship.
Denying the family pension to her, only on that ground.
Lordship,
This issue needs to be examined.
Lord,
You respond to this petition, we'll admit this, we'll hear it on someone.
Lordship.
Take it. We have heard Sri Kaustubh Das, learned advocate for the petitioner, and Mr. P. Nayak for the state.
Yes.
You're P. Nayak.
Yes, Lord.
Yeah, I'm trying to remember the names of all the advocates, and P. Nayak, counsel for the state. By the impugned in the present appeal, the judgment passed by the learned single judge dated 22/8/2024 in WPC 1177 of 2017 has been questioned. The appellant is the wife and widow of late Suppu Burman, who worked as a work-charged chowkidar against a sanctioned vacant post. For such service, he was paid regular salary and was extended all benefits of grade 4 regular employee, including GPF. His services were duly recorded and service role also was maintained throughout his tenure. However, unfortunately, despite a drive by the state government under a scheme dated 39/2025, many persons, the services of many working on the muster roll and work charge establishments were regularized. In fact, the number of such persons who were the beneficiaries of such scheme was approximately 8,000. Possibly on account of oversight, the name of the husband, late husband of the appellant, was not included in the list of such beneficiaries of regularization. The employee later died in harness. Died in harness. The executive engineer, public works department, respond number 4. Realizing the mistake, wrote the government for posthumous regularization of the employee only for the purposes of securing family pension to the appellant herein, whose husband had served for around 30 years continuously. The learned single judge, on finding that the family pension scheme is under a statute which operates with all its interdicts, so that spelled as interdicts, with all its interdicts, did not allow the prayer of the widow Prima facie, the reasoning employed by the learned single judge appears to be unassailable. But in a case of this kind, in order to mitigate excessive hardship, we deem it appropriate to give a further hearing, to give a detailed hearing in the matter, to find out as to, under such circumstances where there is where there is no doubt that an employee would have been regularized but for the mistake of the government, whether there should be such a strict reading of the scheme in order to avoid making payment of family pension to the widow of the deceased employee. This petition is admitted for hearing. List this.
May I pray, Lordship, in this case, Lordship? So far as the writ petition is concerned, Lordship, my affidavit is already there.
That's what
But in the writ petition, Lordship,
she is not getting pension.
just one issue, Lordship.
We will hear it and find out some way of finding
Just
some.
one issue, Lordship. I'm praying for one opportunity to file one affidavit just to rebut one claim, Lordship. In the writ,
So we don't admit it. All right, Mr. This requires to be heard. Mr. Nayak, however, submits. Mr. Nayak, however, submits that he shall be responding to this appeal before.
only on one issue, Lordship, may kindly record that, Lordship. In the writ petition, Lordship, nowhere it has been mentioned that he was working against a sanctioned vacant post. In the appeal, Lordship, first time he is claiming that his service was against a sanctioned.
As a legal, Mr. Nayak,
That point,
learned counsel for the respondent, however, submits that it is for the first time that an averment has been made in the appeal that the deceased employee was working under a sanctioned vacant post. He wishes to file his response to the appeal. Let him do so on or before the next date with a copy in advance, with a copy of the affidavit in advance, with a copy of the affidavit served in advance on the counsel for the appellant. 2 weeks. 2005 papers. Date statement.
28. Item 17.
Yes. Yes.
The appeal is against the judgment passed by the learned single
You have to
judge.
speak in the mic.
Microphone.
At times I fear whether I have gone hard of hearing, but then. This- Yes.
The appeal is against the judgment passed by the learned single judge dismissing the pair of the petitioner for condonation of his big service from 2007 to 2014. My lord. For condonation of he was appointed allegation in 2003 in the district. Thereafter he was transferred to Majuli and thereafter to Dibrugarh, Borburwa in 2006. My lord. In 2007 he was removed from the service on the plea that one Normata Sethi has filed an petition before the Honorable High Court by to which authority was directed to appoint her. But there is no mention of the mention about the removal of the present petitioner in the judgment passed by the Honorable High Court. The judgment is, my lord. The Normata Sethi judgment is, my lord, page 48. Page 48 is the judgment. Heard Mr. B. Sethi, learned counsel for the petitioner, and Mr. D. Goswami, learned additional senior government advocate Assam, appearing on behalf of the respondent, issue rule. The rule is made returnable within 6 weeks. No fresh step need be taken for service of the respondent to as Mr. Goswami appears for the already respondent. Copy of the writ petition has already been served upon him after going through the annexure after dated 9th April 2002, written by the divisional program officer ICDS cell Tezpur, Sonitpur, to the Director of Social Welfare and Probation Officer Assam, Guwahati, shows that the petitioner was selected as a grade 3 LD come typist and got second position in the interview held on 32 and 2000, but she has not been regularly appointed. The petitioner is serving in the department since 31st March 1995 till date as the fixed salary. But since 1119, she has not served, received a fixed salary also. Therefore, in the interim, respondent authorities are hereby directed not to disturb the service of the petitioner until further order and to pay her the fixed salary with effect from so and so till that if the amendment made in the writ petitions are found to be correct by the authority. The tendency of this writ petition shall not be barred for the authority to consider the case of the petitioner. So during the pendency of the petition, already Normata Sethi was appointed, my lord. So when he was appointed, that petition was withdrawn. This order is, my lord, page 53. Page 53. Mr. B. Sinha, learned counsel for the petitioner, on instruction submitted. And the petition is not placed as meanwhile the petitioner has been provided with the necessary relief. So she was appointed, my lord. But the
Finally, it got formalized. And what is happening with Langur?
Normal days I could not find it. I think he was given information, but I don't know.
Yes, who appears for the state? this seesaw thing happening?
Yes,
It's a very interesting spectacle, no?
that is very interesting.
He was appointed,
Initially appointed,
initially appointed,
then
and
it was
he was
challenged
terminated because somebody else at serial number two.
to have
challenged,
challenged.
The
Yes,
appointment, he was not even noticed.
he was not a
And
party.
then he goes to court, challenges the appointment of that number two in the
Lady.
merit list. He or she, Narmada.
She.
She got removed, he was appointed.
Yeah.
And thereafter, what happened? Again?
Therefore, after he is claiming for the back wages for the period in the interim from where he has been removed till the date he has been reappointed. So
But he
now,
was number- he
now
was-
as regard that part, that court has clearly come out in their judgment. So there is no dispute to that fact that for back wages, there are, if your lordship goes.
It's never automatic, that's true.
That's. So that is his case at the moment.
But did he work or not?
No, he was not working.
It was only formalized.
He was illegally removed, my your lordship, see the annexure 7.
No, they were interpreting that appointment to be reinstatement. That is what has been discussed, and it has come to the conclusion by the learned.
What is it?
The appointment order has been again given to him when the coordinate bench has interfered into the matter, and that has been interpreted as a reinstatement. And for which he is claiming from the date when he was removed till the date when he was reappointed, he is claiming the back wages for that particular period of time. So that is what is.
But my removal was illegal because there is no mention in the High Court order. Your lordship, can you see the annexure 7, page 39, the order removal? Here they have mentioned about the High Court order, but that order does not speak that he should be removed, my lord. There is no mention.
All this, all this business seesaw took how many years?
From 2007, I think.
1996,
Yes,
approximately 11 years.
yes. And thereafter, again, he approached the court after another 7 years.
Yeah. This is again, now his services were formalized when 2013,
14.
14.
Yes.
And this writ petition was filed when?
It was filed in 21, 7 years. Yes.
No, Mr. Sarma. We were initially inclined to think about it because it was not your fault, but you should not have been appointed in the first instance.
That's true.
In the last
In
paragraph,
place of a person who had a better merit than you.
last paragraph, the informed judgment may be seen. There, it is stated that we are not taking step in time. Last paragraph kindly be seen, my lord.
Last paragraph what?
Yes,
Informed judgment.
Informed judgment.
Yes.
Informed judgment, last paragraph. The factors of which are required to be considered by the court before the
Where are you reading? Paragraph 15.
paragraph 15, 14,
Page 107.
107, my lord. The
Tell me
passing
the
the
paragraph number
paragraph number to 14.
of the judgment.
Judgment, yes. Page
Paragraph 14,
107.
12,
Last paragraph the petition, my lord.
14.
Last paragraph.
14.
Factors which are required to be considered by the court before passing the specific order for grant of back wages, either in part or in full. No such discussion is found in the judgment and order that the 14/11/2013 passed in WPC number 10014, 14/2007. If there is any ambiguity in the order, there are sufficient remedies available available to the petitioner to take recourse to. However, such clarification cannot sought for by filing the subsequent writ petition that too after the period of 7 years and which required interpretation. The pair may be rejected.
What
My
do
lord,
you say to this?
2014 I was appointed, my lord. In 2018 I am not getting salary, my lord. I am fighting for salary. I am fighting for salary. 2019 I approached the
Back wages.
authority that I should be given a benefit.
Take up.
And thereafter COVID period start, my lord. COVID period start, I could not file. So at least direction may be given to the respondent also to consider a representation to be filed by us, my lord. I'll file a representation. There should be directed to consider, my lord.
The appellant chair, we have heard Mr. K. Sharma, learned
Sharma.
advocate for the appellant. Mr. S. Barua for the state. The appellant herein had sought back wages under the circumstances that he was initially engaged in service on grade 3 on ad hoc basis in the year 1996. No, yeah, what have I said? No, under the circumstances that he was appointed on the post of LDA cum typist in the year 2001. But his services were terminated at the instance of another person who claimed to be higher than him in the merit list. This termination order was behind the back of the appellant. As a natural corollary, the appellant challenged such termination order and challenged such termination order, but his services were secured. All this happened by around 2013. It was only in 2021 that the appellant came before this court seeking back wages for the period that he had remained outside the service on account of his termination in the first instance. The learned single judge rejected such claim on the ground that the appellant had only been appointed and not reinstated. After long legal battle, the appellant could get his appointment. Under such circumstances, there could be no justification for payment of back wages, which are not automatic. It would be dependent on various factors, none of which was brought to the notice of the learned single judge, including whether the appellant was gainfully employed during that period. That apart, finding that the appellant had opposed the court after 7 years of his appointment, and that during the period that he remained out of service on account of termination of his service, which also was because of the claim of the other person higher in the merit list in the selection process. We find the decision of the learned single judge rejecting the prayer for grant of back wages to the appellant to be absolutely justified, requiring no interference. The petition is dismissed. The appeal is dismissed.
Yes.
Item 18.
Yes.
May I appeal, Your Lordship? Your Lordship, in this case, the petitioner has applied before the respondent number 2 for providing assistance in taking over physical possession of the secured assets under the provision of SARFACIA. That petition was filed on 21/11/2024. As per law, the DM has to dispose the petition within 1 month.
for giving reasons only not later than 6 months. Is that correct?
No,
What does the
within
rule
2
say?
months, within 2 months,
So 60 days.
60 days.
So that's what the rule says, no?
Yes, madam.
Yes, then
So since the DM is not acting, we have filed this petition
For a direction to the
petition for
DM.
direction.
yes, what do you have to say?
Lordship, I took one instruction, Lordship. As per their instruction, initial letter which bank has sent on 9/5/2025, land measuring 16 lessa was.
You have to address that immediately. You know, that is the purpose of enacting the act.
Lordship and
By taking all necessary safeguards into account.
and Lordship, with Office of the Deputy Commissioner, Office of the.
You have some instructions with.
Yes, Lordship.
What instruction? Put it on record.
Thanks.
What instruction is this?
And Lordship,
I mean, I've not been able to follow this communication. What does this mean?
Lordship,
If you have good, you have not put it on record.
Lordship, it is for first time, Lordship, so I.
Good that you did not put it on record. Keep it with you. Don't give it to the bench. We don't understand. There is no instruction. Take instructions, positive instructions by
Lordship,
tomorrow, day after tomorrow.
Lordship.
Notwithstanding the Canara Bank, petitioner, notwithstanding the Canara Bank, the petitioner, having applied before the district magistrate, having applied before the concerned district magistrate for securing the possession of the property under section 14, the district magistrate has not acted pursuant to such request despite passage of 60 days. MSRB Boral and Council for the State seek some time to take instructions in the matter before addressing the court. Let that be done by the next date, next week. List to next week. And please go through the communication made to you before passing it on to the court.
Lordship, I am saying that there is some portion of land is less, which is asking for Lordship. 16 lessons land.
That is not the instruction.
Another set of instruction I have to provide it, Lordship, in mail, Lordship.
Yes.
Item 19.
May I please, Your Lordship?
Yes.
Lordship, this writ petition is directed against an order passed by the Learned Armed Forces Tribunal, whereby the service of the.
Can you give us just 1 minute?
Yes. Lordship.
And there is a provision for second service pension.
Yes, yes.
In the army.
No,
But it was short. He did not complete.
It was short. I am not on the question of condonation. Yes, he is entitled to condonation, but under the army rules, he is entitled to condonation for 6 months.
Not more than that.
Not more than that. That is my issue.
And this was 10 months and 10
Yes.
months. And
That is.
let notice be issued. to respond number?
The sole respondent.
So let notice be issued to the sole respondent on the steps being taken. That's a look before that. That's a look. This petition challenges the order dated 1/10/2024 passed by AFT, Regional Bench Guwahati in OA number 19 of 2023, whereby the respondent has been allowed the second pension despite his not having served for 15 years in the DSC, which was his second engagement. The period fell short by 10 months and 2 days. The condonation of such shortage is only for 6 months according to the rules. The contention of the petitioner / Union of India is that's condonation of 10 months shortage, 10 months shortage of the minimum qualifying service is beyond the mandate. Let notice be issued to the respondent on steps being taken by the petitioner / Union of India within a period of 1 week, 2 weeks,
Lordship.
1 week or 2 weeks. In the
Uh,
period of
Lordship,
2
let it be
weeks,
returnable by 3 weeks because he's from Nagaon. I'll take steps within 2 days, Lordship.
take steps within a period of 2 days, both modes returnable on after 3 weeks spectator.
Lordship, I'm praying for a interim stay because if they go for an execution.
Nothing will happen. Nothing will happen. Next day. Argue on the next.
22nd August. Item 25.
Yeah. Yeah.
Item 25.
Yes.
Your Lordship, in this case, I'm appearing for the state of Nagaland, Your Lordship. Process is being undertaken. It will require some.
What is the matter about? We should know. Who appears for the petitioner? Prachuria Borua.
Lordship.
You have filed in a private capacity. Yes.
This is a matter for publicity of the witness protection scheme in the case of Mahendra Chawla and others versus Union of India. Here, through an RTI, I have come to know that hardly anybody, only one witness has applied for protection since the scheme came out in the entire state of Assam. So in the light of the witnesses becoming hostile everywhere, so I see it as the duty of the judiciary to publish the scheme in the form of.
The notice to public at large. So state, unless they have filed a PGB, there is an order on Nagaland to thank you. That's all.
No, you have to, by saying something. Is there a notice? Is there an order?
No. This is 21.
What is the order? Let's see. Yes, you were saying something, Nagaland.
Yes, Your Lordship, I'm appearing for the state of Nagaland.
Yes.
Process has already been initiated.
What process?
For this application of this scheme.
No, that is this is no concession by any state. You're bound to do that.
Yes,
The issue is something else. He says that since the scheme has not been circulated to the public at large, they do not know whether it exists.
Yes.
And therefore, they are not taking any advantage of it. I mean, I don't think it's a case which is arguable now by him, but let us see, what process have you started?
Collecting all the data and all from the other this thing,
I don't think you have understood the
districts and all, and it is being
no, no, what is the affidavit of Arunachal Pradesh? Who appears for Arunachal Pradesh? What have you said?
We have already considered the committee lordship in each district lordship. And then an amount of 20 lakhs has been earmarked for this.
For dissemination of the information. I don't know. We will see this. We'll see this PIL also. It's an important thing. Let's see.
Yes, there is another aspect to
Let
this
me
PIL.
put the affidavits of these states, and then we'll see whether implementing a scheme and bringing it on the portal of the government of India, is it not circulation good enough?
Lordship, the judiciary has to see the effect of the publication on
Judiciary
the.
has to see the impact, that's all right. But circulation, do you mean to say that if there are lesser number of people who want to take benefit, that amounts to no circulation, no dissemination of information?
No, people want to take the benefit of the scheme
How do you
because.
say so?
Because
And who are you? You are a lawyer.
yes.
And how do you know what statistics do you have that people don't want it?
No, because of the witnesses are becoming hostile, Lordship.
That's something else. Is that the only indicator? Is that the only index on which it is decided that people don't know the law? Have you conducted any survey? Do you have any data? One statement that people have become hostile, witnesses are becoming hostile, therefore they do not know about this. I don't know. I don't know about this case, but
no, that is the observation of the.
70% of the witnesses go hostile even in cases of murder.
No, that is the observation of the Supreme Court, Lordship, in the Mahendra Chawla case.
Don't quote Supreme Court offhand. The observations are in a different context. You are suggesting a different context. Since this PIL has been entertained, therefore we will carry it out to some extent to some day.
Lordship, there is another aspect of this PIL. Kindly, another
Try and
completely
understand, young
different
man.
aspect.
Try and understand, young man. Merely because the only information that you have is many people are turning hostile. They are not supporting the prosecution case.
Yes.
Is that the only ground for you to suggest that people have no idea? I mean, why do we entertain this PIL? कुछ तो research किया होगा ना? You would have made some research. Pilot cases, maybe in different states. You have geared up. You ask the states to pull up their socks, but for what? They need to spread the law. There are so many laws. Are you aware of all the laws? It's a notice in rem. See, people have to be sensitized. That's different. That is different. For that, I think we instead of more than the state, our judicial officers are supposed to tell them that this is the benefit that they want, that they can take. What will the state do here?
Lordship, one banner displaying the witness protection scheme before the police stations will do, because the government is anyway displaying their
They do
schemes.
something about it. You're right. So what do you suggest?
One banner in front of the police stations and outposts will do, Lordship. And since this case is the cornerstone of the judiciary, if the witnesses are becoming hostile, the entire justice system is affected.
We would ask you to refrain from making such casual observations. Onus of judiciary is to decide cases, to reach out to people, to give justice at the doorsteps even. But then calling it as onus for asking the witnesses to depose against somebody, that I'm afraid that may not be possible.
No, I'm just asking them to be fearless.
Before we conclude, before we close this petition, without their response also, we can do something. Now, like one suggestion you said, before every police station, there should be a banner telling people who are visiting that police station that they have got these rights, they can exercise that. And we will also think of activating this through our legal services authority. Right. So we have so many people here, but then for witnesses, I don't think some good place, we will have to sensitize our judiciary. But what will the state do here? The litigation is against the state. The prosecutor is the state.
No, even the registry of the High Court is the party. Yeah. The respondent number
We'll
one.
see it on some other day.
And there is
No,
another.
just a
aspect
minute.
to
What
this
is your name?
Procedure Borboro.
Mr.
Borboro.
Borbua. Mr. Young Counsel, we are very happy at your efforts, but then you formulate, you tell us something, some points, what can be ordered. We will have it in short on some next day. Give a list of things that you want to happen.
Lordship, my prayers are very
I'm
clear.
asking you to take some time and not state just now. You make a list of what would be a better way of disseminating such information. All right. We shall formulate it, couch it in an order, and we'll see that your concern is, addressed. Okay. So like you said, police station, there should be a flex advertisement. Likewise, you can also say that people, how do you want the state legal services authority or the district legal services authority to work in that regard? Kindly suggest to us.
Another thing that could be done is that the witness protection scheme can be displayed in the website of the Guwahati High
That's
Court.
one.
Yes.
That display part you've said, think of something more. We will be very, very conclusive in passing an order.
Yes.
But unnecessarily asking for from the state, what do we do?
So actually, state was only not party. By actual this program, they are made party.
Yes.
Because that's what a Supreme Court judgment. State has to also do something.
Every center has, but nonetheless, we'll conclude it.
Yes, and there is finally another aspect of this PIL. That here in the Mahendra Chawla case, the Supreme Court has ordered.
Formulate your points, put it in 1, 2, 3, 4 in a numerical form by the next date. We'll look into it.
Lordship. Deeply obliged.
As grateful on behalf of the petitioner, re-notify us. Give a date after. We are giving you 2 weeks. Please do some homework. Enlighten us what we can do. We will ask. We see is right. We see that you have not even made the states parties. You have made the High Court a party. We will look into it definitely.
No, now they have been made party.
All right. Give us some suggestions.
Lordship.
We'll try and do it in the, if not in the order, we'll try and sort of enforce it through our administrative machinery.
Deeply obliged.
All right.
18-8.
We'll come back after 5 minutes. Yes.
Item 26.
Your Lordships.
Yes.
This matter relates to management of a temple, my lord, called Haigreve Madhava, which is about 30 kilometers away from Guwahati. And my lord, issue before your Lordship is that, my lord, in 1908, in a title suit, there was a judgment of the, my lord, district judge, which, my lord, laid down the procedure of the management of the, my lord, the temple. Now, in 1959, an act came into being, my lord, for management of the religious institutions. The act is called, my lord, Assam State Acquisition of Lands Belonging to Religious or Charitable Institutions of Public Nature Act 1959. So under that act, my lord, there is a provision how to constitute the committee. Now, my lord, there is a difference between the, my lord, the judgment of the Honorable District Judge and, my lord, this committee. Two committees are a little different. This application has been filed, my lord, this PL has been filed so that, my lord, the committee is constituted as per the act. That is the limited prayer. And, my lord, let it be managed, my lord, because there has been, my lord, allegation of mismanagement and, my lord, accounting. What happened, my lord? The last
Give us 2 minutes, Mr. Chaudhary. who would be the concerned respondent? I think after the enactment of the special act, this decree is, this cannot be treated as a constraint.
My lord, the district, my lord, the deputy district commissioner is, my lord, if your lordship kindly comes to the impugned order at page 132, my lord. That is where, my lord, he is afraid to
Which
give.
order?
Page 132, my lord.
132,
Right.
yes.
And that is the reason, my lord, why the petitioner had to approach this honorable court, my lord.
Just. This is lands belonging to the administration such as must be the other. We'll just see.
Now, your lordship may kindly come next.
Just,
my lord.
just a minute.
My lord.
You're referring to a division bench order dated 3/5/2013.
My lord.
Can we have that act of 1959?
My lord, my lord, I have quoted the relevant provision.
No, that quotation would not be correct. But it's not of but nothing about management. Of these. Mr. Chaudhary, can you point out any enabling clause in the act which talks about management?
My lord, this act itself, my lord, says.
Show us from the act, any provision with respect to management.
My
Because you
lord,
see, the preamble to the act is
section 25A, my lord.
25A.
Right. May I read it, my lord?
Utilization of annuity. Verification of.
No, my lord, may I draw your.
One second.
My lord.
Is there any enactment called religious trust boards or something? Assam State Religious Trust Board or something? Nothing.
No. Now, my lord, may I draw your lordship's attention to page 142, that is the last order.
One second, Mr. Chaudhary.
How to look in position on these provision, otherwise it is how to legislate a particular position.
But then annuities, to control of the matter of utilization of the annuity, verification of the proper maintenance of the Institution.
Deputy Commissioner, there is also that elected body, but Deputy Commissioner is there by the district.
But proper maintenance of the institution, yeah.
Except like the elected of the average.
National graduate. And have you quoted the decree of the civil court?
Yes, my lord.
Where is it?
That your lordship finds that, my lord, is the decree itself, my lord, at page 54.
Page?
54, my lord. It starts at page 54. And it has, my lord, constituted a committee that your lordship will find at page 55.
But this, and where is the amendment to this Act of 1959?
My lord,
There's an amendment also.
there is an amendment, my lord. In fact, my lord, I have stated at page 17, my lord, I have made this statement, my lord.
Page?
Page 17, my lord. Ever made. After this amendment, my lord, page 17, I have quoted that, my lord. The amendment is 25.
That's amendment.
87.
This came in 87. But for these temples to be recognized as religious institutes, then only the act will apply. There would be some board which would decide that this institution or the temple or any charitable institution has to be registered with a particular board or something. Where is that problem?
My lord, the problem faced by the deputy commissioner like to.
So you're right, your public interest litigation would succeed in a different way. If you say that this, I mean, if you make us, if you convince us that this relates to the management.
My lord, if your
This
lordship kindly.
management, this managing committee is for the purposes of managing the land. Land which is to be acquired, the belongings from where the rental comes for the maintenance of Doloi's family. Whether it is for the management of institution, management of annuity, I can understand.
Annuity, my lord.
Annuity, I can understand.
One of the problem that has been faced by the deputy commissioner is reflected at page 142, my lord. That is an order passed by the deputy commissioner. The last but one paragraph, your lordship may kindly see, my lord, at page 143. May I read it, my lord? Last but one paragraph at 143. In the instant case, although the present institution is receiving annuity from the state government and therefore falls within the ambit of section 25A, but in view of the decree passed in Title 3 of 1904 and consequential directions, the undersigned cannot take over the management of the Hagrid Madhava temple, Hazo, as prayed by so-and-so, unless there is a direction and order of the Honorable Court. Now, the result is that, my lord, last elections were held in 2013. And, my lord, although the period is only 3 years, there is no elected body. The earlier, my lord, the committee is continuing. An affidavit could be helpful, my lord. The affidavit has not been filed yet.
Who appears for the state? Have you responded to this petition?
So far, my lord, the contention raised by the petition.
No, have you responded to this petition?
No, my lord, I have received some comments, but that is.
What comments have you received?
My lord, this comments is not sufficient to file any affidavit. That is why I have written.
See, we would like you to file an affidavit whether this act of 1959 applies to the temple. Is it treated as a religious institution for the purposes of this act?
That,
And
my
what is
lord,
the-
that position, my lord, is admitted, my lord.
Mr. Counsel, is that you don't allow the court to come.
Oh, my lord, I'm extremely sorry, my lord. I'm extremely sorry.
See, we cannot speak side by side, can we?
No, no, my lord. I'm extremely sorry.
So if you file an affidavit, you have to first let us know that this act applies to this temple. Right?
Right.
We see the preamble of the act, it is with respect to management of the acquisition of land attached or appertaining to the temple. In the process, they have come out with an amendment in 1987 about constitution of a managing committee. With respect to the annuities, all right, for annuities, this act has to be followed. If Mr. Chaudhary is only looking for proper management of the annuities, so far so good. The DC or anybody will not be having any constraint because of the decree passed earlier. That's a different thing altogether. But so far as regular day-to-day maintenance is concerned, whether the temple will have its sole right or whether it would be governed by this act, these facts you have to bring on affidavit because you know it better. Don't point out other anomalies in the petition.
No,
That
I
it
am-
was earlier seen, it was earlier taken. See, these institutions need to be, managed properly. These are places of culture, of religion. I'm told that there are certain temples of 10 Mahavidya here, somewhere near Kamakhya, which is in total disrepair. So these are the institutions which attract people to your state. Right, this has to be maintained properly. The concern of the petitioner is not ingenuine. He doesn't want him on the managing committee. He doesn't want him to be replaced. No. He only says that under the act, the scheme has to be implemented. So you have to tell us whether this act applies to this.
My lord, may I point out one thing, my lord, that page 40, the order passed by the deputy commissioner, which reflect, my lord, this comes under the purview of the act, my lord.
Page?
Page 140. The 138, my lord, order start of the deputy commissioner. Page 40, last paragraph, my lord. Temple was given 37 bighas of lands. During the enforcement of the Assam State Acquisition of Land belongs to the Religious and Charitable Institute of Public Nature Act 1959.
One second.
And although the.
1 second.
My,
Annuity from the government. ये क्या क्या मतलब? No, the annuities are being received by the government, Mr. Chaudhary. I thought annuities, the connotation of annuity was the money generated over the lands attached to the temple.
No, by the government.
No, it is being given by the government. Land of 37 acres also given by the government.
Yes.
Therefore, the act is applicable.
The last part, last paragraph, page 141, last but one paragraph, your worship may kindly see. That is where the, my lord, the hitch is.
This is a trouble for the deputy commissioner.
Decree loses its force with the creation of law. Let them file an affidavit. They say that they have received 37 acres of land. The act is for something else. It is for. No, no, therefore the management now, the land now. He says, yeah, no, it was, no land was acquired. It appears that they have been given or they have been left with 37 acres. They are not ready to say anything, no. Mr. Chaudhary, the state is slightly ambivalent. You find out and tell us. Under this act, this is for the purposes of acquisition for which notification has to be issued.
Yes, yes.
Suppose a temple is having 100 acres of land. Temple is retaining and the government wants to take it by way of acquisition for various other purposes, for resettlement, for people, for tenants, whatever. Now the government would allow some part of the land to remain with you. If that is the case, or it could redistribute after acquisition. So if that is the case, there are three different aspects involved here. If 37 acres of land has been, temple has been allowed to retain the same, that is one. If temple has been given 37 acres of land, that's second. And if 37 acres of land have been given along with the annuities, then the commission has to be constituted in accordance with the act. But we only want to be doubly sure that there is no special status of this temple which is governed by any local tradition or local usage or whatever, and does not form part of this building. So we do not know from any one of the deposition or the order passed by the deputy commissioner that this 37 actually belonged to you or was given to you.
Well, I understand.
That you must say, and then we will decide this decree will not come in the way of your prayer. We will clarify.
Yes.
Let them file their affidavit. I don't know whether the gentleman lawyer has understood or not.
Right.
You have to tell us everything about it, no? Because we'll be stoking the religious sentiments also if we pass that order.
Yeah.
There is no confusion in our minds. With the enactment of this Act of 1959, the decree becomes meaningless. It cannot be a constraint on deputy commissioner to constitute a managing committee under 25A. That's a basic premise of law, basic concept of law. Right? The legislation has to prevail.
That's true. My lord, the impugn order which has been passed by the deputy.
There is no impugn order here.
There is an order,
It's a-
my lord.
There is an order.
There is an
Oh,
order, my lord.
Impugn.
There
Which
is,
order?
in fact, my lord,
Deputy commissioner's order.
Deputy commissioner should know.
page 144.
The moment you impugn this order, then it no longer remains a public interest litigation. What are you talking, Mr. Chaudhary?
My lord, here the.
You can bring this order into account. You can bring it to the notice of the court. But this does not remain a public interest litigation after you impugn an order.
I have brought it on record.
Then you have to file a requisite petition under Article 226, not to be registered as, then it goes before a single judge.
Now, my lord, what happens by this order? My lord, an election was directed to be held as per the, my lord, old scheme. I mean, the scheme of 1908.
उसको challenge करने के लिए तो दिल्ली needs to be a party.
This was filed by some socio-cultural organization. No,
Then there is no longer an impugned order. You have brought it to the notice. There cannot be any impugned order here.
I did not pray for any stay also, my lord. This I have brought it to notice, but then my
We
lord,
are saying something else.
my lord.
See, this is, who's the petitioner here?
My lord, petitioners are two, my lord, public.
Two individuals, members of the public.
Two individuals.
All right. Now, this order by the deputy
138.
commissioner, it was under a petition filed by whom?
One Nobo Karana socio-cultural organization. 138.
138.
Board is my lord.
Who has filed this petition?
That's second period. One no, seen pages the applications applicant. Seeking to invocation of 25.
No, fair enough. That was pursuant to the order which you showing.
No, Prana is not filling.
It's no longer an impugned order.
So they couldn't implement. He was not the petition.
Have you understood what we are thinking?
I have understood, my lord.
If this order is to be challenged, I think you are no authority. This can be challenged only by Nav Prerna, which had pursuant to an order passed by a division bench of this court in PIL, had gone to deputy commissioner. Now you are somebody else.
Yes, my lord, I am not.
You are bringing to the notice of the court that this is not happening. But the manner in which it has been done, otherwise also it would have come before us. But this was to be decided by a single judge. So therefore, forget about this order.
Yes. I am ready for that.
If you want the PIL to be entertained by us, this order you don't show us.
My lord, because of annexing this order, your lordship will not non-suit me, my lord. Because these are simply brought to your lordship notice.
They need to file it. Kya naam hai? What is your name?
DK Sharma.
Mr. D. Sarma, you file an affidavit. Tell us in detail what is the situation. And where has Nav Prerna vanished? Nav Prerna should have come.
Yeah, Prerna should have come. Nobody has come forward. And these
So
two
this will
gentlemen.
be a second petition with the same cause. Now, there are certain difficulties where, before entertaining such petitions, we shall. It concerns temple, we shall. But that has to be explained. File your affidavit.
Right.
And please address this aspect also.
If your lordship, my lord, see the prayer portion, my lord, the prayer is for set aside and was the.
That prayer is there, my lord.
No, then it is not. Then it is not a
There is
PIL.
one of the many prayers, my lord. One of the many prayers.
We'll have to deal with it now.
My lord, the prayer before.
We'll have to explain. We'll have to explain. That's the point. Otherwise, we should not have entertained. And then this could not have been challenged in PIA. You don't challenge the court's orders in PIA. We have heard Sri M.K. Chaudhary, learned senior advocate for the petitioners, who are public spirited citizens, and Mr. D. Sarma for the state. The petitioners seek management of. The petitioners are aggrieved by the mismanagement as a cut paper. The petitioners are aggrieved by the mismanagement, negligence and misuse of resources by the managing committee of Hayagriv Madhav Temple, Hajo. Earlier, 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 a petition was filed before this court in public interest by Nava Prerna, a socio-cultural organization, Hajo, seeking proper maintenance of the temple, and also highlighting that with the promulgation of the Assam state acquisition of lands belonging to religious or charitable institutions of Public Nature Act 1959 and its amendment in 1987, incorporating section 25A mandating constitution of managing committee for proper management of the annuities and verification of proper maintenance of the institution, the management committee ought to have been constituted and should have started functioning. First, it appears that in the PIL referred to above, Nav Prerna was directed to approach the Deputy Commissioner, Kamru Amingam, pursuant to which a petition was filed before the Deputy Commissioner, taking note of the grievance of Nav Prerna, the Deputy Commissioner did not accede to the prayer of Nav Prerna for the reason of there being a decree of a civil court by which a special scheme was constituted for the management of the temple in question. The present petitioners, not at all, so next paragraph, present petitioners not at all associated with Nav Prerna have however filed this PIL challenging such order of the Deputy Commissioner dated 25/3/2014, which erroneously appears to have been erroneously impugned in the present petition, which does not make this petition a public interest petition. Nonetheless, considering the fact that this petition was entertained, it has not been ever entertained.
Notice was issued.
Considering the fact that this petition was earlier entertained and it relates to management of an institution, of a religious institution / temple of great public importance, we deem it appropriate not to advert to the aforenoted technicalities in entertaining this petition. The prayer of the petitioners, therefore, is the prayer of the petitioners otherwise in public interest is that with the promulgation of the Act of 1959 and there being a special provision under the Act for constitution of a committee for management of annuities and of the other affairs of the temple, any decree passed by a civil court in that regard would have to give way to the provisions of the enactment later in point of time. Enactment later in point of time. Nonetheless, we would require an affidavit from the state to apprise us whether the lands owned by the temple in question has been allotted to it by the government under any scheme, or they have been allowed to, or the temple has been allowed to retain 37 acres of land which originally existed and owned by the temple, and whether the annuities referred to in the petition are the annuities generated out of the land appertaining to the temple, or is referable to the annuities given by the government. Stop. If the annuities are allowed by the government, then perhaps there is no doubt that there would be application of the Act of 1959, and therefore the respondent state would be under an obligation to constitute a committee under Section 25A of the Act for management of the affairs, as also the annuities of the temple. Let the affidavit clarify all such aspects and be filed positively on or before the next date. Re-notify so and so.
Second August.
Highly obliged.
Item 29.
Yes.
My lord, as per the last order, my lord, the planning council, Guwahati University have to obtain the instruction. My lord. It is matter relates to, my lord, the continuation of the affiliation of the respondent number 10 institutions under the Guwahati University in violation of the section 14 of the NCT Act, in spite of the withdrawing of the recognition by the NCT, my lord. As per that, my lord, the section 17(1) and 14, if the NCT is recognizing the.
1 second, we'll get back to you.
Yes, my lord.
Hold on for a minute. Who appears for the Guwahati University?
My lord, I appear for respondent 1, 2, 3, and 4 Guwahati University. My lord, on the last occasion, this honorable court has.
And who appears for NCT?
This PIL is not in the tune with the Guwahati High Court PIL rules, my lord, 2011.
Why?
Rule 10, 1F. Only, my lord.
No, the issue is very important. Therefore, we'll ignore that. The issue is really important. It may not be in accord with the rules for filing PIL. They have not given their introduction. Let them not give it. It has been brought to our notice. We can even take suo motu notice on this. All right?
Milord.
So therefore, we will not be bound by those technical rules, especially when it does not, I mean, those rules are of the High Court, all right. We have the authority to ignore that for particular purposes. Now tell me one thing. NCT Council first. Now, when you disaffiliate, when you cancel the affiliation, you have withdrawn the recognition. Is that correct?
Yes,
When did you withdraw the recognition?
that is in my lord, annex.
Page 38, 39, 40.
Let him say. Huh?
It's 30.
I've asked you for the date, not for the page.
21.
22nd March 2021. Has the respondent number 10, the training college, Mirza,
Yes,
has it appealed to you that no, please don't do it? We will make up for the deficiencies. Is any appeal pending before you?
No, I have not.
You have no instructions on that. Now, who appears for the college? Respond number 10.
Milord, may I submit, Milord?
Just a minute, let's have the issue known. Who appears for respondent? Don't, please keep standing, no difficulty. I mean, I'm not asking you to sit down. You must understand. I mean, who appears for respondent number 10? Has it been noticed? Is there a notice to respond number 10?
No,
You have to say yes or no.
first day only notice.
This is the first day.
No, the first day that was not issued. My lord. His direction was only to obtain the instruction.
11-6. What does
Notice was not issued yet, my lord.
this is respond number 10. Yes. Now you
Milord, the matter, Milord, in this PIL, Milord, it is pending before Delhi High Court, Milord. And
how does it?
Milord, regarding
You
running,
stated it is pending before the Delhi High Court.
Milord,
Because NCTE is located in Delhi.
Milord,
But because it concerns Guwahati University, the High Court of Assam, High Court of Guwahati can also entertain it.
Milord. Milord, since Milord, a stay order has been granted on 7th July.
Stay of
Stay of that withdrawal of recognition by NCT.
it has been stayed.
Yes, Milord.
Show us. The Delhi High Court would have been better advised to send the matter here.
Maybe general order. There are number of petitions, Milord.
Who's the person?
Asset. No, much better.
You have given the application. This is a petition.
Milord,
Where is the order?
the first few pages, Milord. WPC 5369 of 2025.
Respond number 10 is the writ petitioner before the court. Respond number 10 is the writ petitioner before the court. They deliberately went there.
Respondent number 10 is the college concerned, and that college concerned has moved the Delhi High Court.
Well, he may be a petitioner there. Whether he may be the petitioner there, we are
Milord.
see,
Whether present petitioner has taken stage for notice upon
then otherwise also here, even if he has been able to obtain a stay of the order passed by the NCTE.
Milord.
NCTE, what was the stand of NCTE? And we don't find the order. Where is the order of stay?
Paragraph 14 and 15, Milord.
Paragraph 14 and 15 of what?
That order, Milord, order dated
You've
7.
given me the petition, not the order.
Milord, in the first few pages, Milord, this is the order.
But there must be some order, no? Doesn't it what? Order, Vikas Maharaja. Vikas Maharaja.
Paragraph 3, 4, and 14, 15. Serial number 1 is the petitioner's colleague. All over in
And what is the next date?
28th August. Para 14.
So therefore, they have, the university has got a ready-made answer for the time being. You tell us what, suppose this stay were not there. Suppose, think of a situation when this stay were not there. Now, what would you have done?
Then we will have to de-affiliate the college concern. And one more thing, Milord, I think it is very, very relevant to the public interest litigation. There are 4 directors. One director has moved his PIL, and another director has moved 4 petitions regarding running of B.Ed course. And
No, this is,
for this honorable High Court.
this is by a body, no?
And only page 37 is there, Milord. It is totally in violation of Rule 10(1)F.
Then we'll take.
No indications of any other director.
Just a minute. No. Let us see what is his identity.
Nothing has been given. Page 37.
Educational Foundation incorporated in the Companies Act to promote.
Number 5, my lord, I have mentioned, my lord. And today, my lord, one additional affidavit is going, my lord, is being filed regarding the another director identity, my lord.
No, just a minute. If it
There
is
is
a
only
vested
2 directors, not the
information,
4.
it will come down to everyone. You contest his identity. You say that he also runs the runs such a institution.
Milord, he says. One of the directors, Milord.
But I am not, my lord. I'm coming with all the affidavit, my lord. Whatever he is saying, but I am not, he's not the
Then
director.
we'll dub it as a vested interest litigation and will come down heavily on him.
Yes, my lord.
Will impose costs.
His pleadings like that, my lord. But today, my lord, I am going to file, it is being filed, my lord, the affidavit additional regarding the another director's identity, my lord. I am coming with all
director
documents.
is on bail, Milord. One police case is pending against him, Milord. The principal is also there, Milord.
I don't know, my lord.
What could be the purpose of filing this PIL?
My lord.
What could be the purpose of filing this PIL?
No, my lord, whatever.
Are you controlling respond number 10?
Yes, my lord.
Are you controlling the respond number 10, or are you having some other institution
My lord,
which is in competition with respond number 10?
No, my lord. This is, I am, my lord, separately, my lord, body, my lord. I am a separate identity with a company registration. I am doing, my lord, all the interest of the students, education purpose and other purposes also. So, my lord, all the communication prior to that, my lord, I made to the authority concerned to know the things, my lord, that was not relevant, my lord.
Take it.
So now the affidavit is being filed, my lord, today regarding the another director identity. My lord. But whatever he is saying, it is not true.
He just say. The petitioner claims to be an educational foundation incorporated under the Companies Act 2013 with its office in Assam, which works for promoting, developing, and establishing facilities for improvement of educational, social, cultural, economical, and medical relief to the poor and downtrodden, and for advancement of any other charitable or developmentary objects of general public utility, and community welfare. Full stop. It also promotes art, commerce, science, sports, and a host of other activities. The concern of the writ petitioner here is that despite the affiliation of the Teachers Training College Mirza, bracket respondent number 10, having been withdrawn by the NCTE Act 9, by the NCTE acting under the provisions contained in section 17 bracket 1 of the NCTE Act 1993, the respondent Guwahati University, bracket respondent number 9, has not disaffiliated respondent number 10, resulting in respondent number 10 admitting students and accepting money from them. The petitioner questions such act of university in allowing respondent number 10 to take advantage of the gullibility of the students. Mr. P.J. Phuket, learned Standing Council, Government of Assam.
Guwahati University.
Government of Standing Council, Guwahati High Court.
Sorry. Guwahati University.
Learned P.J. Phuket, learned Standing Council for the Guwahati University has raised a preliminary objection with respect to the maintainability of this PIL for the reason of the petitioner not having disclosed his full identity, and therefore the petition not following the petition not in terms of the High Court rules in that regard. He has further informed this court that one of the directors of the petitioner firm owns a college for training, owns a teachers training college. And perhaps this is only a vested interest litigation. He has also submitted that respondent number 10 and many other institutions whose affiliation was withdrawn by the NCTE have approached the High Court of Delhi have approached Delhi High Court in a series of writ petitions, the lead case being WPC 5369 of 2025 by respondent number 10, in which an interim order has been passed on
Date declared 7/7/2020.
on 7th of July 2025. Staying the operation of the withdrawal of the recognition of such institutions. And the next date fixed in the matter is 28th of August 2025. The Mr. Mahanta, learned advocate for the petitioner, submits that an additional affidavit is being filed shortly explaining the identity of the petitioner, the details of the registration of the foundation, its article of association, and some other details about the other directors, one of whom is reportedly facing criminal prosecution, which fact has been informed to us by the Standing Council for Guwahati University. Standing Council for Guwahati University. Let such an affidavit be filed positively by the next date. We are keeping it next week only, by the next date. Prima facie, it appears to be a vested interest litigation. List this matter on so and so date, after 1 week only.
One copy of this, relating to this finding in the Delhi High Court.
I'll provide you.
No, why? Why? You are the petitioner. Oh, respond number 10. But you are aware of everything. No?
I am not aware of this.
Or give him a copy.
I'll provide a copy.
Edit.
Most of them.
Item 30.
Item 30. Yes.
May I please? Our land has been acquired in the year 2007 by the National Highway. And some award has been given to us. We not satisfied. Therefore, we have approached the arbitrator as per the provision of the law. And arbitrator has given two relief. One is solicium and interest that we are entitled. And another is a revaluation of the building. The competent authority has done the second part, revaluation of building, but the competent authority has not done anything with regards to solicium. And your lordship may come to case.
But haven't you accepted the money after the reassessment? Haven't you accepted the money after the reassessment?
No.
You have.
Till then, they have not paid the additional.
That's different, but Ocha, you have not.
Earlier, we have received.
Come to paragraph 13 of the judgment.
Considering the petitioner willingly accepted the amount of reassessment by the respondent authorities pursuant to the order of the arbitrator. So we have agreed to accept only the reassessment of the value of the building. That is the wrong findings, your lordship.
Just give us 1 minute.
We have never accepted.
Just a minute. So whatever was not challenged, whatever part of the order passed by the arbitrator was not challenged, that amounts to admission. So therefore, do you need a special clarification by the single judge with respect to solicium, additional compensation, interest, whatever?
In this case, your lordship, we have never accepted the same. The findings is a wrong findings, your lordship.
How do you say that?
Because
satisfied parties. Okay. Where is that? Where is that page?
Page 64, between the direction. Page 64. Direction. The second part was done, first part was done, and this was it.
In position, while fixing the valuation of land shall be included as per direction.
Now this has been aligned. This is expected, but this part is not, and it is expected.
Which part is not?
The solution, first part. Solution, second part is elevated, this payment is given.
But he says that also he has not.
Solution of the part, second part is button. It is.
No, no, Mr. Counsel, you need to tell us, have you received the solution
No,
No,
no.
and other considerations?
Other consideration, that is the second consideration to, till that we have not received. Only the
Yes.
single bench has directed.
Their prayer in the repetition is, may kindly go to page 41.
Page 41.
Yes, Lordship. That and any other appropriate other direction should not be issued directing the respondents to reassess the adequate compensation payable to the petitioners in respect of land, measuring so and so, covered by Doug number so and so, village so and so, and the building in terms of the order dated so and so, passed by the Commissioner Lower Assam Division, Guwahati in arbitration case number 56/2011, and also causes being shown. After hearing the parties and on appraisal of records, be pleased.
That's right. Why do you have to read the prayer in its entirety?
He has not challenged in a read petition regarding the solution.
He is not aggrieved by that. He says that you must pay the solution, the first part of the order.
Because
valuation of land, solution and other things. The other thing which he has challenged, we will deal with it.
The solution regarding Lordship, page 64, that while fixing the valuation of land and solicium and other considerations shall be included as per direction of the state government. The state government has directed to reassess the value, land building value. As per the direction of the state government, the value of the building has been reassessed. And that has been amount to rupees 2,08,000. Like that.
Solution is not.
So we are ready to pay that amount, Lordship. But before that, Lordship, page 63, the order of the arbitrator, that after going through the reports and careful consideration of all relevant records, the following observations are made. That as far as the land is concerned, the Deputy Commissioner has fixed the value of land through a procedure in record with jurisdiction.
Justification.
Justification, sorry. As the Deputy Commissioner has fixed the value through relevant procedure and application of mine, I find no reason to differ with the decision of the Deputy Commissioner to that extent, as mere proximity of the land to nearby town may not be justification enough for similar valuation. The proximity of road, availability of approach, communication system are some of the few considerations and that play a part towards valuation of a land. However, the order of the Deputy Commissioner does not indicate whether solution and other considerations as stipulated by the Honorable Apex Court, as well as direction of the state government, were included in the same valuation. That direction was not there regarding for payment of solution and interest.
See, there is no option for you but to calculate the solution and offer it to him.
But this is a very old case, Lordship.
Old or new doesn't matter. You have to give him.
2010, the land was acquired. But now it is 25. It is a very old cases. All this in the Tarsem Singh case, Lordship, it has been after the enactment of that Right to Fair Compensation Act, Lordship. The old pending cases should not be opened.
No, should not be opened for the purposes of reevaluating, reassessment, not for the purposes of, nobody is reopening the case. Is he asking for a compensation under 2013 law?
Yes.
No.
No, he's not asking.
He's not asking for it. So where is the prayer for reopening?
So, Lordship, it's all pending cases, Lordship. At this stage,
This is it has not become stale, you see. You acquired the land, you use the land, you are ready to give compensation. Compensation is
But
not
they-
complete.
They have never paid. for
Compensation
interest
is
of
not
solution.
complete without solution. I don't know what single judge has done. Well, let's
But
see.
now they have paid before it lordship in the writ appeal lordship for payment of solution and interest.
No.
There should be some directions on the state government regarding solution. Mhm. Mhm.
The appellant has laid a limited challenge to the judgment impugned in the present appeal, whereby the learned single judge has not addressed himself to the issue of payment of solatiums and other amounts awardable to the appellant, which would be based on the valuation, which would be based on the fixation of, which would be based on the fixation of the valuation of land. The arbitrator had ruled that the assessment of the building needs to be made as per the prevailing market value as on the date of taking possession of the land by competent authority. This assessment has been done and the value assessed has been, value assessed is not disputed. Some part of the assessed value of the land was not paid, for which the learned single judge directed for immediate disbursal of the same. However, what aggrieves the appellant is the non-payment of solatium and other considerations which are part of the compensation which is required to be paid to the appellant. The learned counsel for the respondent state submits that it is an old matter and therefore no solatium is required to be paid. That, are you saying this?
Yes, one thing is that
I should not put this argument in your mouth.
No,
Because this is a wrong, basically a wrong argument.
They have not challenged the arbitral award lordship.
But he doesn't want it, no.
Yes.
He doesn't want anything.
But
Award he is accepting. He just wants. I don't know why she's not understanding. Any senior of yours who is appearing in the matter?
No.
No, she's this. Acha, so he's not agreed by the assessment. He says the exemplar, the nearby sale, exemplar, everything is acceptable. Solatium, there is a statutory requirement. You have to pay the solatium.
There you go.
Again, learned counsel from the respondent state, however, has no answer to the non-payment of solatium to the appellant. Stop. Considering this aspect of the matter, we modify the judgment of the learned single judge to the extent that the amount payable to the appellant would include solatium, which ought to be paid to the appellant along with the balance amount of 2 lakhs or something, along with the balance amount of 2,08,000. The appeal stands disposed of with the aforementioned modification in the judgment of the learned single judge.
2,28,600. Obliged.
Item number 32.
Amount of 2 lakhs?
2,28,000.
2,28,000.
May it please, Your Lordship.
Yes.
So this is a tender matter wherein we have challenged the very process of evaluation that has been done herein. So the tender is a two-bid system. The present tender.
Evaluation of the technical.
The evaluation process in totality. The tender had otherwise a devised mechanism. A methodology was prescribed in the tender terms and conditions. Now, giving a complete go-by to the prescribed procedure, what the authorities have done, they have brought in a completely foreign methodology which doesn't finds place in the SBD.
Show us.
Yes.
Show us.
May I first show the methodology as prescribed in the tender? Or
Yes, yes.
Lordship
Then
will
only
kindly
you'll
come
be
to.
able to show the departure.
Yes, Lord.
Show that.
Lordship will kindly come to page 99.
Yes.
Page 99. This is the instructions to bidder. Now this is under clause E, bid opening evaluation. Now if your lordship will come to clause 22.5. Basically, clause 22 deals with the bid opening. 25 is relating to the examination of bids, determination of responsibility.
22.5?
Yes, lordship. Evaluation of part 1 of the bids with respect to the bid security, qualification information, and other informations furnished in part 1 of the bid in pursuant to clause 12.1 of the ITB shall be taken up and completed within 14 days of the working period of the date of the bid opening, and a list will be drawn up of the qualified bidders whose part 2 bids are eligible for opening. So it's a 2-bid system. First, the technical bid evaluation will take place based on clause, if a lordship will come to page 89, clause 3 and clause 4 are the criteria based on which the technical bid evaluation will take place. That is at page 89.
Yes.
Now, once the bidder qualifies the first stage of technically being qualified,
That we know.
then
no?
yes,
Just
that is the normal process. Yes, lordship.
That's a normal process.
Yes,
that
lordship.
we-
And
we
then
don't-
your lordship will find that 22.8, just for that math, 22.8. Part 2 of bids of only those bidders will be opened online who have qualified in part 1 of the bid, 22.8.
Yes.
Just to indicate that this is the normal tender evaluation process that is otherwise followed in a 2-bid tender system. 22.5 and 22.8 I have just shown. Pursuant to that, your lordship will come to page 100, that is the examination of bids and determination of responsiveness, 25.1. May I read, Lord?
Yes.
Yes. 25.1. During the detailed evaluation of the part 1 of bids, the employer will determine whether each bid meets the eligibility criteria defined in clause 3 and 4. B has been properly signed, is accompanied with securities, and all those details are there. 25.2 now deals with a substantially responsive financial bid is one which conforms with all the terms and conditions and specifications of the bidding documents without any material deviation or reservation. I'm just not reading the entire thing. 25.3, if a bid is not substantially responsive, it will be rejected by the employer and may not be subsequently be made responsible.
And what has happened now?
And what has happened is the financial bids were opened on 27/11/2024. Thereafter, the evaluation and the result was not published. The petitioner thereafter applied under RTI on 27/1/2024 as to what has happened. Then under RTI, certain documents were furnished to us that your lordship will find from page 100, page 511. There the deviation is there, page 511. The appeal memo is a bit bulky because the bid papers are annexed.
But you have docketed it properly, so there is no difficulty.
Oblige your honor.
Yes.
Page 511, lordship.
Yes.
Now 511 is the RTI on 27/1/2025.
Yes.
Wherein we had asked as to what was the result of the tender evaluation process. Now therein, at page 512, we have been now given the work order. The work order has been given to the private respondent dated 14/1/2025, wherein it has been indicated that SN Enterprise with the private respondent at a financial figure which is 19 crores 66 lakh, which is higher than the one that I have quoted, was been awarded. Now, how do they award it? That is at page 513.
No, but without publishing the result, without.
The results have not been, it's an admitted position. The results were not published. It is only under RTI. We were informed.
It must have been uploaded. So we'll have to have the.
So that is the admitted position, lordship. That day it's not uploaded.
The private party didn't make the. Private person didn't make the party.
Page 513 and 514.
SN Enterprise.
Now, if your lordship will come to page 513.
Just a minute.
Yes, lordship.
Your team. Yes. You always do it, first division. Let's see the judgment.
Page 40 is there. Page, that's the, it starts as page 27.
Ah, I got it.
Judgment starts with page 27, and the relevant paragraph would be paragraph 39, page 49.
Page 30 and 40.
Internal page,
Internal page,
internal page of the judgment.
23, Lordship.
23 and 20.
Lordship, you can see from page, paragraph 38, internal page 22. Paragraph 38, internal page 22.
It's not even uploaded on. And you say that you have been non-suited despite your also having offered a competitive price.
Technically been found to be
Technically, the other
qualified,
person, the other.
and financially been giving a better rate. My rate was lower, I was the L1. Now, the evaluation process stated that it was the L1 who is to be found to be the most responsive.
But this technical petition not rejected.
No, it's not rejected. If a lawsuit will come to page 513.
Work order is given to a person who was not the highest bidder, lowest bidder. He is the lowest.
That is there, that paragraph.
The methodology followed is at page 513.
No, that's still. And the court said that really if the procedural.
It is not for another procedural, but only thing is that he did not attend the petition.
Who?
This petition.
He-
The next previous paragraph. Admitted the statement and the paper.
Paragraph six?
After continuous statement and the paper. The petition did not, was not paper.
That's the basic thing. That I think.
Yes,
Nothing can be done, that's different.
Is the reason. The internal page 24, paragraph 40 is the. Yes.
इस पैराग्राफ में यहाँ
Very popular.
bid meeting का कहाँ
Bid meeting for 39. 39. The statement made by the.
have to be loaded over the possible.
Then only we know the. Everything for hotel, eat and double. System is written.
Yes, quoted all the. It would give. She doesn't provide the patient. Yes, who appears?
Lordship, I'm appearing for the state.
Now, which requirement which requirement tells you that you will not upload it on the website? Final result?
Lordship, it was uploaded.
No. The judgment says no.
No, it's an admitted position, it was not uploaded. And my ground is that it was not uploaded because they follow the hidden criteria. Page 513 may kindly be seen, Lordship. What procedure they adopted, what methodology they adopted, page 513.
Methodology, that you're not questioning. You're only questioning non-uploading the final result of the financial.
That is one aspect. And my
Other we will not see, no? Other we will not see for a different reason, because you have you did not participate in the pre-bid meeting. Therefore, you are not aware of it. This thing does not change the rule of the game. So therefore, if you have participated, you chose not to participate in the pre-bid meeting, but you have accepted to the terms and conditions. You can't now sort of go hot and cold. The only ground which you have and which you can seriously contend is that it was not uploaded. Therefore, there is some apprehension of entire thing being done under cloak and dagger. That's the only argument that you can possibly
just allow me 2 minutes time to just place my case for my satisfying my own anxiety, just for that matter.
The procedural follows gives statements only become test-based, not PMGI, which was supposed to be followed for. But not the diffuse yes.
No, PMGI is the
work on our work. They have tender committee decided that will not follow PMGI 3 because it's relatable to technical. That
yes, you wanted to say
yes, Lordship. So once I participate, I am bound by what are the terms and conditions of the tender.
All right.
Now, if the authorities adopt a foreign methodology, am I not entitled to challenge that because it's a hidden criteria?
Instead of giving your comments, you just show what you want to
Page
say.
513, Lordship. Because I had shown the methodology that is prescribed under the SBD, that is the tender terms and conditions. What they adopted to is a minute of 10/8/2023, an internal minute of 10/8/2023, which is predated the tender. It's not a part of the tender process. Page 513, if Lordship will kindly see. They started giving marks now. And how they have given these marks? They rely on the next page, 514. These are not part of the SBD. These are not part of the standard bidding documents. They are not tender terms and conditions. These are hidden criteria, prescriptions which have not been revealed. Page 513, Lordship will kindly see.
Yes.
SN Enterprise, the private respondent.
Yes.
They have given on the technical aspect, technical score 100, weight is 60%, financial 96, weight 38. And finally, he has been found as 98.601. Vertex construction, again, certain marks have been given. How are they giving these marks? It is not there in the NIT. It is not in the terms and conditions. This has not been out there in the public domain. And they rely on the minutes of
There was no cost assessment required under the NIT.
It was not there. It was not there. The NIT was a pure NIT of that 2-bit system where I passed the technical qualification and thereafter responsiveness on the basis of the financial. That is what the prescribed procedure.
In technical qualification score, respond number 4 got more marks. Therefore you.
How did he get it? And how,
that's right. But you said you were L1.
Yes, I was L1.
You could not have been L1.
No,
L1 only by the basis on the basis of the financial offer that you had made.
Yes.
On that basis.
And that is how the process
finally you're not declared to be L1. That's right. The assessment was wrong.
Also, the process prescribed under terms
What
and
is the
conditions.
current status? Limited reply.
They will always say substantial work is over. They will always, but there is no delay or laxity on my part.
No, that's right. But we will see unless there is a public interest. I mean, if there is a public interest involved, that shall be taken into account.
Sometimes.
What is the stage of the work?
And Lordship, as per 24/6/25, that is the report dated. They have already completed 39.62. So another 10 days extra.
So in this regard, there is one proposition laid by our coordinate bench, which says that if there is no delay or latches on the part of the petitioner while approaching the court, there cannot be a defense of this nature on the other side.
But why did you adopt this as strategy?
That's it.
But what is there for you to show now? I mean, we are not asking strictly on account of, strictly on the parameters of the law laid down for commercial transactions.
Yes, Your Lordship.
But you tell me, how do you say that it was with the purposes of helping respond number 4? Or there was some malafide?
Yes, there is a malafide. When there is a hidden criteria, when the prescription as to what the methodology would be is not been prescribed.
This criteria would have been displayed.
Yes.
And it must have been told in the pre-bid meeting, which you did not attend.
It is not.
Okay.
I say so why? Because there is a ground for that. 94, clause 94. If I may just, clause 94 provides that whatever is there in the pre-bid meeting has to be brought in by way of an amendment to the SBD. That has not been done. So therefore, it indicates that in the pre-bid meeting, not me, in fact, no bidders must have asked this question. And again, the duty is cast upon the tendering authority to bring all these things, not for me to question. Page 94, amendment clause is clause 10. Anything that has happened in the pre-bid meeting has to be incorporated by way of an amendment to the tender terms and conditions. Otherwise, they cannot rely on that. And it is not, the duty is also cast upon them to bring it in public domain. Also, there are judgments of Datta Associates which clearly states whatever prescription you are using, it has to be brought to public domain prior to the bid submission. Had it been the normal process of technical evaluation and financial evaluation, I was the L1 and I would have got it. By bringing in this numerical methodology of giving marks, I have been non-suited. And they do not have a ground as to how this was incorporated, how it was brought in public domain vis-a-vis this tender process. If it is not, it's a hidden criteria. And the Supreme Court have again and again said that that cannot be done. Hidden criteria cannot be entertained. There was nothing stopping them from bringing it by way of an amendment to the tender terms and conditions. They have not done it. Only when I filed for RTI, it was disclosed to me that this is the methodology we are applying.
Yes.
That way, probably it cannot be, it's not a transparent process.
Mr. S. Sharma, learned advocate for the appellant, and
It's M.
M. Keshi, learned AG, learned additional AG, Nagaland. The appellant has questioned the judgment and order dated 23/5/2025, passed by a learned single judge of this court in WPC number 12 of 2025, whereby the challenge put up by the appellant has been rejected. The records reveal that the appellant and respondent before participated in a two-bid system under a two-bid system. Both, the appellant as also the respondent before crossed the technical threshold, technical responsiveness threshold. Thereafter, their financial bids were opened. The Land Council for the appellant has drawn the attention of this court to various clauses in the instruction to the bidders and the information regarding the procedure to be followed in assessing the tenders of the participants. The method described in the NIT/instruction to the bidders was the normal procedure of assessing the financial viability of the tender by taking into account the offer made by the party. He has further submitted that so far as technical assessment of the bid was concerned, it was good enough for a party's tender paper to have crossed the technical responsiveness score. Beyond that, it was only the offer made, it was only the assessment based on an offer made by the contesting parties, by the competing parties. The question raised on behalf of the appellant herein is that a novel procedure was adopted, perhaps a procedure which was agreed to or formulated prior to the floating of the NIT, in which the technical assessment was numbered, technical assessment of each of the participant was numbered, and a weightage was given for the number allotted to a party in the technical assessment. It is the case of the appellant that he lost out only on the ground of his having scored less on the technical front than respondent number 4, who could manage 100% marks. 100% marks. In any view of the matter, he submits that there can be no two opinions that in such matters the choice is of the employer. The choice is of the employer. The choice is of the employer of the services, but the fault line lies in introducing a new method of assessment of the tender offered by parties, whereby marks were given and assessed for the technical on technical score. The appellant had offered the best. The appellant otherwise would have been declared L1. The learned single judge on a perusal on a perusal and assessment of all the case laws on the subject came to the finding that it was not necessary for the respondent state to have agreed for the lowest rate offered. Such decisions are based on other considerations. So far, so good. But the question here is that whether it would be an acceptable method of computation when the same is not made part of the NIT. The second aspect of the matter, which has been highlighted by the learned counsel for the appellant, is that even the final result was never uploaded, and the appellant could know about the work order having been given to respondent number 4 only when he applied for such information under the RTI. He therefore directly infers that the entire assessment process of the tender papers was under cloak and dagger, and therefore vitiated. On our query, the learned additional AG of the Nagaland has informed us that the respondent number 4 has completed work to the extent of 39% up till now. Let notice be issued to respondent number 4. Anybody appearing? What do you have to say? You have filed your response? You have filed your response?
In the writ petition stage, they have filed.
No, here, it's okay. You file your response here with this aspect of the matter. No. You will file here. Yes. What no? We are asking you to file it here.
I'll file it out.
The respondent number 4 is represented by Mr. Mr. Moa Jamir, learned advocate. he submits that he shall be filing as a response to this, to the memorandum of appeal by the next date. The matter requires, the issue requires to be heard. First up, list under the heading of hearing on after 4 weeks.
So can I pray for a status quo lest it becomes infraction?
Work should not stop.
Oblige you not. Sir.
4-9.
We will see, we will saddle the state with cost or something and.
Only thing is that it should not be rendered infructuous on the next occasion by saying 99% is over or something. Oblige you not.
4th of September.
4th of September.
Item 33.
May I please, Your Lordship?
Yes.
My lord, a tender was published by the Honorable Guwahati High Court to supply, my lord, this 2 kVA UPS and 7 kVA diesel set. My lord, I was a bidder to that, and my bid was rejected simply on the ground that I have been blacklisted.
You say simply on the ground. That's a good ground for rejection.
Yeah, so that's why I am before Your Lordship to know where is that.
Because we claim that was not blacklisted, but it's shown in the curriculum as blacklisted. No recapitulate, not recapitulate.
Now, हमारा confusion में रहता है कि order P where he is where matters in the first instance in the.
No, there
But should it not have gone before the single judge?
My lord, I was asked to file 2 copies because it would be
Actually,
taken by.
there is a notification. You will kindly have, something is written in down below, my lord. You will kindly, my lord, I'm sorry, I have got only 1 copy, my lord. I'm extremely sorry. Perhaps because of this, my lord.
in which party report is adding to the party.
All right.
But in this matter, I'm appearing for respondent number 1, 3 and 4, my lord. I have received the instructions. My instruction is that, my lord.
What is your name?
I am HK Das, my lord.
SK Das, you are for the High Court.
Yes, my lord, standing counsel, High Court.
Yes.
My instruction is that the tender process, which is in question in the repetition, that tender was cancelled. Thereafter, fresh tender was issued. And pursuant to that fresh tender, another party was selected. And he has completed the work. Payments are also.
What is left here now?
I am not demanding any work to be allotted to me, my lord. I am simply, I am simply have filed this one to know that whether IIT has ever blacklisted me and whether there is any proof for that.
Who tells you that you have been blacklisted?
Yes, my lord, page number 29, my lord.
Page number?
29.
And in the second bid, did you participate?
Yes.
And you were unsuccessful?
Same answer.
Same answer?
Same answer.
Because in the GN is going to be affected by RT, but he has never received any blacklisting order. So they need to clarify whether I told you.
My lord, the last slide, the firm was blacklisted by IIT Guwahati. I have never been blacklisted.
Why the High Court should not accept such statements, no, without verifying?
No, there was a letter by the IIT, my lord. I have got
Where
that.
is that? Where is that letter?
Yes, ma'am.
Giving the letter, it is not a copy.
Let us see. You have the copy, you have the letter,
Yes.
copy of the letter?
Yes.
Show it to us.
Lord, the entire.
Let us provide some remedy to.
Yes, my lord, he should.
This cannot go on forever.
First is the list of the.
We want.
Second, the next page, my lord, will kindly have.
What is his name?
Better power
services, my lord.
Better power services.
Yes, my lord.
Better power service, list of blacklisted firm. Blacklisted for how many?
2012 to 2014.
Only. And thereafter that blacklisting lifts.
Milord, our condition in the tender was that, Milord, we need a party who was never blacklisted anywhere, Milord. That is our clear stand.
Let them submit a reply, my lord, along with the
This letter
copy
is
of that.
a copy. It is not from IIT. You have prepared an inventory, but what is the source?
Milord, the next page, my lord, will kindly have.
Next page is better passed.
It was intimated to them.
For 2 years. This is the letter. You give a copy of this letter to him.
Yes, my lord.
Please give a copy.
Yes, ma'am. I'll furnish a copy.
No, have you not questioned why this kind of consideration? That a party who has been listed, because there is a reason why I am saying so. This is an advisory.
Yes, my
I
lord.
should not have been giving you this advisory, but let me tell you. Now, times without number, the Supreme Court has reiterated that this blacklisting or debarment cannot be for an indefinite period.
Exactly.
What is the reason? The purpose is that you can't be put to civil death kind of a situation for all times to come. It is for a limited period.
Yes.
So an institution like High Court should not keep such onerous condition that a person can participate only if he has never been blacklisted. He has to see whether the blacklisting operates during the period when you apply. That's all.
Yes, my lord. My lord.
So you could have challenged that, but you have not. So therefore we dismiss.
No, my lord, soon after that, my lord, I filed an application on 13/11/2010.
Yes, it's all over. For the next one, be very careful. Whenever you participate against a tender, against tender notice, you please write to the party that if this is the condition, then it's useless for me to appear. I was blacklisted 10 years ago. And that also for a period of 2 years.
In fact, there was a
My
pre-bid
lord,
meeting also.
My lord,
There was a pre-bid meeting. Milord, he could have raised this issue in the pre-bid meeting, Milord. That was also not attended. And one more thing, Milord, it was not the only.
We are dealing with a
I understand, Milord. Lordship is correct.
Thus, we are dealing with a private party and the High Court.
Lordship is
These
absolutely
anthems
correct.
are for other people, not for
Lordship
High
is
Court,
absolutely, yes,
which
true.
is the seat of
But
the seat of justice. You can't have injustice done under the nose of the High Court.
True, Milord, true. But
The
one
very terms of the tender, the very terms of the notice was defective.
Milord, only one another information. He
You
was
select him.
no.
You
I'm not on that.
Keep his we are just telling you.
Yes.
Never select such person who has been blacklisted, but you can't put it.
Impose, yes. Yes, Lordship is true. Lordship is correct. But this is not the only reason, Milord.
See, why do you have to press this petition? Why don't you file a fresh petition challenging the decision of GEM or making a request? You ask for a direction from us to bring that blacklisting thing from the GEM down.
Yes, correct.
It has to be removed from the
GEM portal.
Correct,
Milord.
That should be your prayer.
My lord, I will do that, but as per my instruction from the party, my lord, IIT has never blacklisted me. Let him give me that.
See that letter.
Yes.
See that letter.
Yes.
Pour that letter to him at
Yes.
the present.
Yes.
Mr. Sattar, we'll have a copy of that letter also given to you.
Yes,
but for the moment, take it to be true because it is in the records of the High Court file and it doesn't appear to be fabricated.
In that line, I don't blame the Honorable High Court for that, my lord. With reference to the subsection mentioned above, the undersigned is hereby directed to inform you that on the ground of violation of the contract terms, clause 12, so and so, so and so, so and so, your business dealing with this institution, IITG, is stopped for 2 years, that is so and so, so and so. My lord.
And that period ended in 2013.
Yes.
So therefore,
But my lord, here it was the stoppage of the business with me for 2 years, not blacklisting, my lord.
That's putting you on a holiday list. It has the same impact. You have been put on holiday list, or you have been debarred for 2 years, or you have been blacklisted for 2 years. Meaning is same. Though the considerations, the consequences may vary, but meaning is same. Where have they come out with the stipulation that a person should not have been blacklisted ever? Where is that?
My lord, it's,
Show me that condition.
one.
Show me that condition. Mr. Satar, you will not get any relief here for this reason. So everything is done, contract work over,
Yes, madam.
supplies made.
Yes,
Therefore, you should withdraw this petition. This again an advisory.
my lord.
Withdraw this petition, file a petition if at all this ever comes up in future. You ask the GEM first take necessary information whether the GEM portal has this letter of the IIT. If it has the letter of the IIT, it has to be taken down. That should be your, you make a request to the authority. If that goes unheeded, come back to us. We will have it done.
One of my prayer is also here, my lord, to remove that from the gem.
That we can't do here.
Yes, my lord.
That we can't
One of
do
my
here.
prayer.
And where have you said so, Mr.
Lord, it's,
High Court?
I'll just play it.
That should not be the terms and conditions. You can't achieve something by breaking the law.
It is not blacklisted ever. It has not been used, but the word used is that he shall not be blacklisted.
So blacklisting period is over.
True. Lordship is correct.
Then why did you shut him out?
No, not only on blacklisting. There are other grounds also for not selecting him.
Where is that?
Lordship will find in the writ petition itself, they have quoted the reasons. Page 6, my lord. It is quoted, the reasons. Yes.
Page 6.
Yes.
Warranty policy is unclear.
Clause 21 of the.
Oh, yes. You have followed it. Therefore, you are not at fault. I mean, I am only looking at the condition. I mean, this tender condition is not bad.
In my humble submission also, this criteria that you should not be blacklisted in your entire past life, that also, my lord, I don't find it to be very reasonable.
Heard Mr. A. Satar, learned advocate for the petitioner, and Mr. H.K. Das for the High Court of Guwahati. The petitioner is aggrieved by his being non-suited in the tender floated by the High Court for supply of generator sets. Mr. Das has informed this court that the tender notice pursuant to which the petitioner had applied was withdrawn, whereafter a fresh tender was issued, in which also the petitioner had participated, but the work order was given to somebody else. The supplies had been made. At this stage, Mr. Satar has pointed out that he does not want any other relief except the fact that some direction should be issued to take down his name from the GM portal, showing him as having been blacklisted. In fact, the petitioner did not even know that IIT Kharagpur had ever,
IIT
Guwahati had ever blacklisted him. Mr. Das, learned advocate for the High Court, however, showed to us from his set of instructions the letter of IIT addressed to the petitioner about his being put on the holiday list for 2 years. This stricto sensu would not be blacklisting, But even then, but even otherwise, the effective period passed off long time ago. This could not act as an impediment in the petitioner participating in any bid, in any tender where the stipulation is that no bid would be accepted by a party who is blacklisted. There is no blacklisting. The petitioner does not remain blacklisted if what has been informed to us is correct. Is correct. Stop. In any view of the matter, nothing is left in this petition to be decided. Stop. Should the petitioner find that his name has yet not been brought down from the list of debarred / blacklisted parties from the GEM portal, necessary, he can avail of the necessary remedies. He can avail of the remedies available to him under the law. With the aforenoted decision, with the aforenoted observation, the writ petition stands disposed. Defuse.
Item 35.
Okay, but, okay.
Please.
Yes.
May I please, Your Lordship?
Yes, Mr. Bhuya.
My lord, the matter relates to, my lord, regarding where aspirant, my lord, for the post of Assamese teacher in a recruitment process, my lord, initiated. My lord, what has happened? We have the honors in the Assamese subject, my lord.
No, tell us one thing. I mean, I got distracted.
My lord.
What is it?
My lord, the matter relates to, my lord, selection and appointment of the graduate cadre in the recent recruitment process initiated in the year 2023, my lord. Wherein what has happened, my lord, the rule, particularly basing on which the recruitment has been, my lord, initiated, had been amended by making that the person concerned who studied the degree course by taking one of the subject in the degree course can eligible and apply for the post of teachers.
Show us from the documents.
My lord. My lord, may be pleased to find.
Where is it?
My lord, the rule which we are challenging, my lord, may be pleased to find is at page 46. Page 46, my lord. Lord, notice has been issued in this case already, my lord, but no response has yet.
Notice has been issued.
Issued, my lord. No response is required, my lord.
Masudar is not appearing these days.
My lord.
I'm appealing, my lord.
You are appearing.
Yes.
Is that?
Yes, what do you have to say?
My lord, we'll file our affidavit, my lord. Let me give some time.
You understand the difficulty? No, there is a change of the
My lord,
council
my
for
lord.
some reason or the other.
My lord, we are missing Mr. Majumdar very shortly, my lord. That is the problem, my
You'll
lord.
see him in another capacity.
My lord, my lord.
Your name, please?
NJ Khatonier, my lord.
NJ?
Khatonier.
Mr. So-and-so, learned advocate for the respondent, submits that by the next day, the response affidavit shall be filed. Let that be done. Let that be done positively. Re-notify 4 weeks.
My lord.
4 weeks, nearly, no?
My lord, the selection is going to be, or can it be in within
3 weeks. 3 weeks.
My lord. Obliged.
20 seconds. Item 27.
Yeah, please, Your Lord. Lordship, this is in a PIL file by Registered Society and for 150 golden langurs in Bhairav Hill Reserve Forest in Bongaigaon district. Lordship, we are basically approaching because of their mute. That's why nobody is there. That's why we are approaching. Golden langurs are, this is very important. I should speak about the species first, then I will go to the technicalities of this case. Golden langurs are found only in Western Assam, and there are only 1,500 population in India. And that is, and 1/10 of the population found only in Bhairav Reserve Forest. That is 150 plus. And this golden langur is an endangered species. And as per IUCN rate.
Manas National.
Yes.
It is a ceiling, completing the line is required. It's a interest of public interest is called by the. A few villages of Meghalaya are being next.
They got taking out transmission line. It should have.
So what kind of clearance was required for that transmission line?
My lord, all the necessary clearances, my lord.
No, what kind of, I mean, did you have to fell trees?
No, my lord.
Yes, Lordship, the 323 trees have already been felled.
One minute,
Yes.
you have flagged it, let him
Yes,
say.
much obliged.
My lord, the necessary forest clearances are operating in stage 1 and stage 2. My learned colleague here will explain it better. With regards to the transmission line, my lord, these transmission lines, we do it, it's a government, the government creates the project, my lord. There is a proper DPR which happens. Then it is given to us.
It's not the issue in PIL. He says that it should not have been done. The first concern should have been of preserving the endangered species. Now tell me one thing, that thing is over.
Yes.
And you have been able to,
This of this preserved language, my lord.
no, you have been able to scare away those langurs.
No, these transmission lines are, they may, technical side, they may be better, they may better explain, but we have, what we have done, look, they have compensated us for felling of trees, we have carried out plantation in other parts of the forest, and we have installed canopies, man. The langurs without, the monkeys without touching that line, man. Texture regions are there, and they can go through the canopies.
Lordship, my concern is that today I may lose this case, but the risks will always remain here because those canopies they have built is totally unscientific. I cannot imagine, it's beyond human imagination. Some anti-climbers have been, there should be some study report on the basis of which they are putting those all things. We are putting all those golden langurs in a great risk, Your Honor.
I appear for the project proponent respondent number 13 and 14, my lord.
Yes.
While my lord's granting me the stage 1 clearance, the forest department, my lords, has already set up a committee which has recommended the project with certain mitigating features. My lords will kindly see, this is in my counter affidavit. Annexure 12, my lords, 373 should be the internal pagination, my lord. Kindly have annexure 12, page 373.
Yes.
This is the minutes of the meeting before, my lord, I got the stage 1 clearance. My lord will come to the next page, 374, which are the measures that I am to undertake for protection of this golden langurs. The first 2-3 points are very important. My lord, may I read that? My lord has that page 374. My lord.
We are there.
Yes, my lords will kindly see the recommendation. The first one, ground clearance shall be minimum of 15 meters as proposed by the user agency. Plus here I would like to point out, my lords, normally the transmission lines, the height, the maximum height is 9 meters. Here, my lords, 6 extra meters was asked to be put by us, my lords. We did the feasibility report. We have increased it to 15 meters so that, my lords, the transmission lines go through the forest above the canopy of the trees. So that's one part. Let's kindly see the second measure. 3-layer protection measures as proposed to be adopted. 3-layer protection measures will be adopted to ensure complete safety and minimum interference with the fauna. The measures include barbed fencing of tower areas, special tower design having soft material anti-climbing guards and anti-climbing canopies will be installed in Bhairav Reserve Forest area, which will restrict any arboreal animals, including golden langurs, from climbing the towers. This has also been done. I will show all that, Manoj. I will show that each and everything that has been proposed or asked to be done has been complied with in full, full letter and spirit. Manoj will kindly see the third one. User agencies shall prepare the wildlife management plan suggested by the Forest and the Wildlife Department. Now, my lords, please kindly see my wildlife management plan, which I have already, my lords, pictures speak 1,000 words. So I will show, my lords, what we have done and how, my lords, the alignment of the transmission lines is at the edge of the forest. My lords will kindly see page 345 onwards are the photographs. That will, my lords, clarify how the transmission lines have been proposed. Kindly, my lords, turn to page 345.
Just a minute.
I'm sorry.
You are appearing for respondent number 14.
13 and 14. Yes.
13 and 14. This is Nagal Bibra Bongaigaon Transmission Limited.
Lordship, please. Lordship. That is the project proponent.
The user agency.
Yes.
User agency.
They are building it. And there are a lot of procedural flaws also, Your Lordship.
All right, yes.
Yes.
My
Lots of,
Lordship, kindly see page 345.
Page?
345. It starts at 343. We were actually, my lords, there's a bit of a background where, my lords, the petitioner, if I could just place the background so I will be able to put the communications in sequence. My lords will first have page 342, which is the petitioner's representation, page 342. It is the petitioner's representation to the DFO, where all these aspects were pointed out. And my lords, the DFO writes to me on the 19th of September 2022, which is at page 349, seeking my comments and clarification at 349, my lord. 19th of September 22, based on the representation made by the petitioner. Now, kindly see my response. Now I take my lords back to 343. This is my response.
Page 353.
Yes, page 343, my lord. Just kidding. And my lords will please see the reference shows that it says your letter dated 19th of September 22. My lord has that. Now, my lords will kindly see what I have said. The alternative routes, my lords will kindly see. We had, my lords, checked the feasibility of 3 alternative routes. Now, this particular route was found to be the most feasible. I will show the photographs because these lines are at the edge of the forest and not middle of the forest. And if we had moved the lines out of this, the periphery of the forest, this falls in the land settlement areas and hence it was not feasible at all, which is also mentioned. My lords will kindly see in the 4th bullet point, the feasibility to reroute the alignment towards the left side, which is, my lords, going to take it right out of the forest completely. That was also explored, but it had human settlements. So my lords are aware that lines cannot go through the human settlements. So therefore, all these points, my lords, were taken into consideration. And then, my lords, will kindly turn to the photos by which we've shown the alignments. Page 345, my lords, will kindly see that.
Yes.
At 345, the alignment points in yellow and purple are mentioned, my lords. And the forest is, my lords, on the left-hand side. And then comes the human habitation on the right-hand side. And that will be clear from, my lords, the photograph at page 345, the second photograph, my lord. The red areas are human settlements. Now, my lords will kindly see that my lords will recall.
Who appears for the forest department? Yeah, what do you say? That they are not to be faulted. They have found out everything.
Because there's no casualty. And as my learned senior indicated, my lord, the area which the towers are apparently, these are very high. And the animals which are endangered, they are very much below and everything can be taken. And the department is taking every care. Regular checkups have been done.
And the project has been completed.
Project has been completed, fine has been charged.
it is stage 2 clearance have been granted on.
No, line.
No, I'm just.
That apart,
That respond number 13, 14 would
My
say.
lords, the project is completed. The energization certificate, which under, my lord, the act which is required, as my lords are aware, that has also been supplied, my lords. So now the electricity can pass through those lines. So it is complete. It is now, my lords, what happens is that there will be a feeder line which will have to come from another place, my lords, and connected to this spot. But then that is carried out by the department, my lords. We are not concerned with that. We have completed our stretch of the lines. Now the other stretch has to be completed and joined to my line now. So otherwise my line is complete and the electricity passes. And just to satisfy my lords also, whether I have complied with the requirements which have been placed on me by the forest department, kindly see the pictures at page 346 also, my lord, where they had said that barbed wires and other anti-climbing mechanisms have to be put. That those pictures I've also produced at page number 346. I want to show that we have done everything that is required, my lords. My lords, it is very easy to make submissions off the record and say that there are procedural infirmities, but we have to go by the records. My lord, will please see page 346. 346, 347, my lords. And the point that I was trying to make regarding the canopy, my lord, that it goes over the canopy of the forest, is at page 347. The towers rise higher. 347, my lord. This should be a part of my counter, my lord. My Lord Justice Chaudhary has it.
Yes.
My Lord the Chief Justice has it.
Yes.
Am I with my lords?
Yes, yes, yeah.
Yes. My lords, kindly seize page 347 for a minute. Just to show my lords how we have constructed the lines.
Yes.
It rises above the forest, my lord. So therefore, what the petitioners are trying to say that it will affect the golden langurs, my lords, that has no bearing. So wherever there is a transmission, my lords, tower which is falling within the forest, we have towers rising up. So, and every tower, as my lords, I have shown to my lords at page 346, there are to whatever extent possible the technology which is available. Because we have put in those anti-climbing, my lords, those spikes and other things, which will ensure that they don't climb the towers to get electrocuted. So that, my lords, that is one thing that we have done. And the second thing that we have done is we have raised the towers higher. So therefore, there is no question of any, we have tried to keep it at the bare minimum. I can show to my lords, we have produced documents after documents to show that we have tried to keep the felling of the trees, my lords, to the minimum. And there was one other point that the petitioner raises, my lords, regarding the underground, my lords, that it should go underground. Now, there are two problems with that, my lords. If it is underground, then, my lords, all the forest has to be cleaned up completely. Here at least it goes higher.
Lines through the forest cannot be underground, cannot ever be underground.
My lords are absolutely right. And I can show the feasibility report, my lords. I'm not troubling my lords into the technical aspects.
All right, now let me ask the petitioner.
My lord, I'm deeply
Just a minute. You represent early birds.
Yes.
Don't you? And who is heading primate research and conservation division? Ocha, is somebody else? All right. All right, no, Mr. Counsel.
Lordship, kindly write annexure G 83. 83 of the petition. Yeah. This is a report from Conservator of Forest LAFC Bongaigaon. May I read it, Your Lordship? However, the proposed transmission alignment falling at the Bhairav Reserve Forest is one of the highest potential habitat of endangered species called golden langur, which is very much endemic to this state of to this part of state of Assam. The enumerated 330 states to be filled is proposed transmission line. Alignment may adversely affect the habitat survivability on the endangered species, as well as it will lead towards scarcity of food source for primates. Further, the proposed high voltage transmission line will always be a big threat for the life of primate, which is a complete arable in nature. Lordship, it is very important to understand what is arable. Arable is something a species which lives in the trees. So there is all possibilities that this species is going to climb these towers. Number one. And this is the department which says that. It's not that we are saying it. Department. Then what happened? Then there are two divisional forest officers who has opposed this project. Technically, if I speak regarding Forest Conservation Act, this project should have stopped there itself. But what they did was they went to do a meeting and at a chief wildlife warden office. And Chief Wildlife Warden has given some recommendation, which my learned friend which have said is basically the recommendation. Now the question is whether the recommendation can be put in the stage 1 clearance or not. Chief Wildlife Warden is not a competent authority under Forest Conservation Act. Not a single word is there regarding whether Chief Wildlife Warden can recommend a project or not. This is on a technical ground. So stage 1 clearance which have challenged is one of the ground. Number 2 is that Lordship may go to Annexure F additional affidavit.
Now tell me one thing, Mr. Das. Now all said and done, if it has been constructed, transmission lines completed, the project completed, lines are just to be charged, it has to come to the.
So all the things will,
Just-
yes.
You want it to be uprooted.
Yes, Lordship, because all the things will start when they put the electric line. When they climb up the trees, all in a sudden they might vanish this entire 150 population. That is the problem. Because stage 2 clearance has not been given. Lordship, they white 462.
Phase 2 clearance.
Stage 1 clearance is basically in principle. That is only for collecting the money and PV. But here the case is completely different. Even if its contradictory statements are there. Lordship, may kind white page 462 of the additional affidavit, my additional affidavit,
What is
page 462. It says, may I read? It's the stage 1 clearance itself says, after receipt of compliance report from the state government on fulfillment of the condition mentioned above, final stage 2 approval for the central government in accordance with section 2 of the Forest Conservation Act 19 will be considered till the report of final stage 2 approval of the central government for diversion of the state forest land from this ministry. Transfer of the forest land to the user agency shall not be affected by the state government. Only after stage 2 clearance, this transfer of land has to take place. But here the case is completely opposite, Your Worship. Already they have given the land, stage 1, already given they have to the user agency, they have built everything there. This completely contradicts to the Forest Conservation Act. No rule says that. Even the amendment there is no scope for the user agency to build according to the new amendment which has come up. So technically, from the point of view of the law, is also these flaws are there, procedural flaws are there. So they should not have put this recommendation in the stage 1 clearance. That is a big mistake which they have done, technically speaking. And from the point of view of conservation, Lordship, these species are very, very important because
that you need not repeat. We have understood that. Now we are taking your arguments very seriously with respect to, these clearances and what is that stage 2 clearance which the central government had to give?
Under the Forest Conservation.
So then before,
190.
so therefore the argument is that before that you ought not to have allowed the respond number 13 and 14.
Exactly.
My lords, may I respond to that, my lords? I have a simple answer, my
Get
lord.
back to you. I'll get back to you. Can I have your name?
My lords, I'm Chinmoy Sharma, my lord.
Mr. Sharma, we'll just get back to
My
you.
lord.
Yes.
The issue which is bringing up that nature of land is not changed. It's not being transferred. They just contract and they will go away. Land will always remain a forest.
That's right.
Non-forest activities.
Non-forest activities
in forest, there are 2 stages of clearances required. Where is the
Where is that?
clarification?
This is with the.
One is on principle clearance and other is the final.
My lord,
stage 1 is basically in principle, just for taking the money for implementation.
They didn't respond, no?
Yes.
my lord, the clearances work in 2 parts. First, the stage 1 clearance is given. We complete the construction. The line is inspected and the stage 2 clearance is in parallel, which goes in parallel, and those clearances are.
Can you show us the document that there has been a clearance of stage 2?
My lord,
Union government.
as on the, yes, my lord, I can give the clearance given by the government of India from the electricity authorities with regards to the same.
This is forest conservation.
My lord, the forest clearances also will file an affidavit, will bring it on record. The process is how it is done, the notifications, because we have not gone anywhere outside the guidelines that are there.
All right, Mr. Sharma, what were you
Yes,
saying?
my lords, to answer my lord's query in 1 minute, my lords will kindly see the notification issued by the Ministry of Environment and Forest. These are the guidelines, my lords, that govern projects and how the projects are to be taken forward after the stage 1's clearance is given. Please see, my lords, page 491.
Page 491.
491, my lord. And this applies across the country for all projects. There is a sequence to that, my lord. Kindly see page 491.
Yeah.
My lord has that, page 491.
Yeah.
My lord will kindly see para number 2. In supersession of this ministry's guidelines of event number dated 7th May 2015, I am directed to say as below, with a view to facilitate, my lords, please note that this is important. With a view to facilitate speedy execution of projects involving linear diversion of forest, such as laying of new roads, widening highways, transmission lines, my lords will kindly note that. So and so, in principle approval, which is the stage 1 clearance, my lord, under the Forest Conservation Act issued by the central government, may be, my lords, please note this, may be deemed as the working permission for tree cutting and commencement of work if the required funds for compulsory afforestation, NPV, wildlife conservation plan, plantation of dwarf medicinal plants, so and so, so and so, are realized from the user agency. Now, in this case, my lords, after the stage 1 clearance, I have paid the entire NPV which was demanded. The NPV which was demanded was 5 crores 96 lakhs. And my lords, the letter is at page 241. The letter demanding the NPV is at 241.
I have reservation for this, Lordship. I have gone
And
through
my
this.
lord, let me just complete that. So to say that stage 1 clearance is not enough is wrong, because the guidelines clearly say that. And my lords, the way it works is like this. If I could just tell my lords how it will work. Stage 1 clearance comes. As per the guidelines, my lords, I get working permission provided I pay the NPV and I carry out all the other necessary conditions. I fulfill all the necessary conditions. Then, my lords, the project is completed. My lords, for the stage 2 clearance, I need to show that I have completed the project as per the requirements which are prescribed or the conditions in the stage 1 clearance. Because as my lords are aware, in the stage 1 clearance, there are certain conditions which are imposed. So once I fulfill that, stage 2 clearance is the next step. And once the stage 2 clearance comes, it is only a diversion of that forest to the user agency, and that's about it. The actual work that is carried out is from the stage 1 clearance to the, my lords, completion of the conditions under the stage 1 clearance.
All right, you have made that clear.
My lord.
Let's.
Yes, my reservation regarding this notification is that if I have read this notification a number of times, Lordship, I have never found any word which says that we can transfer the land on the stage 1 clearance. It says only two things, two words: order for tree cutting and commencement of work. On the commencement of work, we are on the same page. I have no dispute regarding this. They can start the work. They can pay the NPV and all that they can do all the survey and all that. But because it's a linear project, I have nothing to say. But regarding shifting of the entire plot of land to the user agency, then constructing and putting the tower, only one thing.
What do you mean by shifting?
Transfer of land. That land needs to be transferred to them to do all this kind of work.
They operate through that erected towers. The line transmission line goes through the heart of the forest. That's all. And it is 15 meters. 15 meters is big enough. You know, like human beings, the species, the animal species also, they adapt. They do adapt.
But there has to be some difference between the stage 1 clearance and stage 2 clearance, Lordship.
Your efforts are laudable, Mr. Early Bird. Your efforts are laudable. But here, I think necessary assessment, necessary clarifications have been made. Now it is over. That also is important. A balance has to be struck. There has been no casualty. It is very heartening to note.
The casualty always happen after when that electric line is going to be fixed.
But then
that is the danger factor.
Anti climbers, those
This
canopies.
Scientific, Lordship.
What do you suggest?
There has to be some scientific paper and as to how they are how they have been saying that this is an approved whole over world they use it. Wait, show us to us so that we can also learn, Your Lordship.
We have already filed now the wildlife management plan. That is annexure 15.
There has to
that
be an
is specifically for the
because
golden
all the
langurs,
things-
how we are going to manage.
In my opinion, Your Lordship, there has to be an expert committee which will look into the aspect and say that whether it is feasible or not.
The village we are connecting, Meghalaya we connect those villages, the after independence they are getting power to the person.
So we are not against the development. We know that there is an energy need in this society.
Status of the land, it is not being transferred to state right. Forest department is still the guardian role.
They have done everything in this land, and after that they are saying that we are not transferred. That is very something which is it doesn't it becomes very difficult to digest here.
Doesn't become the master of the land.
You're only the user. Mr. Das, your efforts are very laudable, but considering this, we need to close this petition up. Unless you have something else to offer.
I think there should be an expert committee which should be established and constituted, and this expert committees on the basis of expert committees board. Like because the risks will always be there. This is not which I say. DFO of their department they say that.
All right, that will take care. That will take care. Heard Mr. AK that, but let us close this petition now. For the present, we'll say that the feasibility of having a committee which will oversee and will see what happens, then perhaps they can consider stopping the transmission line, but you can't possibly do that. Because for the first time, as he said, Meghalaya villages have got electricity.
If it goes to periphery also, there'll be only 1.3 kilometer distance, access distance. Because if it goes to the middle for 8 kilometer, if it goes to the periphery, there's only 1.2. They can do it, Lordship. There's nothing much difficulty in this. Only 1.3 kilometer access. Because we have prayed this in our prayer.
That we are not going to do now. We will only ensure that these endangered species and I mean they are not decimated on account of this. That is our only concern. This we are not stalling. We make it very clear to you so that your effort should be, you know, properly channelized while argument. We are not stopping this project. We are not asking them to uproot it and take it to the other side. That's for sure. Considering that this also is important. Prima facie, we are satisfied that due care has been taken. But if you say that a committee has to be constituted to oversee, we shall take care of it. We shall take care of it.
I think we should close.
Take We have heard Sri A.K. Das, learned advocate for the petitioner. And kindly give your appearance slips for the parties. And so forth. So, and Mr. Sharma, you also ask your local council to give your slip.
My lord, my learned friend is there.
The petitioner hearing is a nature care group called Early Birds, which is Early Birds. A concern has been shown by the petitioner seeking intervention against forest clearances granted for a transmission line project in Bhairav Reserve Forest, Assam. The prime concern of the petitioner is that this was highly avoidable and the purpose could have been achieved if another route outside the forest or through the periphery of the forest could have been thought of. The reason for saying so is that the forest reserve is the sole reserve of golden langurs, which are only 150 in number by now, and the species is endemic. With the transmission route through the heart of the forest, it is for sure that several hundred trees would have to be felled. Since langurs are arboreal animals, they would not find any place to climb upon and rest, and perhaps would treat the towers of transmission to be the places where they could hang on, which ultimately might lead to their electrocution. The concern is genuine. Next paragraph. The petitioner challenged, the petitioner by this, in this PIL, the petitioner has challenged a stage 1 forest clearance issued by the Inspector General of Forest, Guwahati, which facilitated the subsequent approval to felling of trees by the government. Mr. Das pointed out that the forest department was very clear in its approach that any transmission line through the forest which would necessitate felling of trees would only disturb the natural habitat for the endangered species. However, later, a committee was constituted of the higher functionaries of the forest department, where this proposal for construction of 400 kV double circuit Bongaigaon Nangali Bibra transmission line. What have I said? Just one line before. I just missed the link. Was discussed, particularly with respect to the feasibility of diverting the transmission line so that it would have least deleterious effect on the forest species. The meeting was attended by, the committee comprised PCCF and CWLW of Government of Assam, nodal officer, FC Act Government of Assam, wildlife consultant, CFLA SFC Bongaigaon, AFS Senior Wildlife Warden, and the DFO of I Valley Division. This committee held meeting with the user agency, bracket respond number 13 and 14 hearing. And the meeting was presided by the Principal Chief Conservator of Forests and the Chief Wildlife Warden, Government of Assam. The committee recommended the project, but with certain caveats. It was decided that the user agency shall keep a minimum of 15 meters of ground clearance when the usual practice for erecting towers, when in the usual practice of erecting towers, 9 meters ground clearance is insisted for. Such high ground clearance was thought of only for the reason of not harming any arboreal species. The user agency was also directed to adopt a 3-layer protection measure for ensuring complete safety and minimal interference with the fauna. This measure would include barbed fencing of tower area, a special tower design having soft material anti-climbing guards and anti-climbing canopy, which will restrict the animals, especially langurs, especially golden langurs, from climbing onto the towers. It was also decided that the user agency shall prepare and submit WL management plans suggested by forest and WL departments. The felling of trees would be resorted only at the proposed tower locations and would be clearly avoided in other areas. So that apart, it was also decided that the user agency would provide fund and support 10 JFMCs for 5 years in and around the forest reserve and other nearby forest areas, which are the habitat for golden langur, for taking up entry point activity, livelihood activities, ecotourism facilities, and capacity building for local youth. The Learned Council for respondent number 13 and 14, Mr. Sharma, has stated that all these directives and caveats were followed to the letter and spirit, and there has been no complaints in that regard. He has also shown the photographs brought on record, which clearly demonstrate that the ground clearance is high enough and that those towers are equipped with anti-climbing guards and anti-climbing canopy, which to a large extent would avoid any casualty. Mr. Das thereafter submitted that a novel procedure was adopted by the government of Assam in allowing respondent number 13 and 14 / the user agency to proceed and continue with the work. The stage 1 clearance is not the license to begin such work, which is not typically a forest activity, but is dependent on stage 2 clearance, which is by the union government. Even if the union government has given the clearance, the procedural lapse on the part of the state of Assam would be evident, as the work should have started only after the stage 2 clearance and not before. In response to the aforementioned contention, Mr. Sharma, Learned Council appearing for the user agency, has submitted that by the communication dated 28th of August 2055 by Ministry of Environment, Forest and Climate Change, Forest Conservation Division, addressed to all principal secretaries of all state governments, union territory administrations. It was made clear that for facilitating speedy execution of projects involving linear diversion of forest land, such as laying of new roads, widening of existing highways, transmission lines, water supply lines, optic fiber cabling, railway lines, etc. in principle, in principle approval under the Forest Conservation Act 1980 (FC Act) issued by the central government may be deemed as the working permission for tree cutting and commencement of work, if the required funds for the compensatory afforestation, net present value (NPV), wildlife conservation plan, plantation of dwarf species of medicinal plants, and all such other compensatory levies specified in the in-principle approval are realized from the user agency, and where necessary, for compensatory afforestation, transfer and mutation of non-forest / revenue forest land in favor of State Forest Department is affected. The State Forest Department is represented by Mr.
D. Gogol.
D. Gogoi, who has submitted that the entire transmission line has been, all the towers over which transmission line would be set up has been completed. Stop. In fact, the only thing required now is the charging of the feeder counter from where the electricity would be transmitted through the lines to Meghalaya and other states. Even with respect to the issue, even with respect to issue of diverting the route of such transmission, it has been argued by the State Forest Department, and the user agency. What have I said? Necessary care was taken that the most feasible, less disturbing route was adopted. In fact, 3 alternative route corridors were studied, largely by maximizing linear sighting opportunities and every effort was made to avoid forest area and the alignment with minimum crossing of the forest area. The route chosen caused least impact. Stop. It was precisely on this assessment that the alignment was selected. It has also been argued that the transmission line so laid will not bifurcate forest landscapes as it is overhead in nature and has long span of cable stringing connecting the towers with additional ground clearance / space beneath the towers and conductors. Thus, it has been asserted that the transmission route chosen was the best route involving forest area, which was unavoidable, and care was taken to keep such forest area to the barest minimum, which was essentially required for the project. With this transmission line, this court has been informed, some of the villages of the state of Meghalaya would receive electricity for the first time. There can be no doubt that electricity moves the nation. Equally important is the forest life and the necessity of preservation of forests. But a balance has to be struck. Development process cannot be stopped, but with least damage to the ecosystem. We are absolutely conscious of the importance of the importance for maintaining the ecosystem and be least intrusive, but at the same time cannot put a Nelson's eye to the developmental process, which in the heart of which, in a developmental process, in the heart of which electricity remains the prime mover. Since the project is complete with no casualties reported, we believe that all necessary care and precaution has been taken. Nonetheless, we do agree with the submissions made on behalf, submissions made by Mr. Das, Land Counsel for the petitioner, that it would require a constant monitoring, for which a special committee be constituted, be directed to be constituted, which would report about any breach or any difficulties arising in the meanwhile after the transmission line is charged. After the transmission line is charged. If all care has been taken to prevent the decimation of the endangered species of golden langurs, even if all care is taken, it has to be seen whether such protective measures have proved effective. Which assessment would be which assessment would be made, can be made only after the transmission line is charged. For that purpose, we observe that the forest that the state in its forest and electricity department shall have a committee constituted to review the impact of the transmission line and its assessment, and in case of any need, suggest ways and measures to alleviate the damaging factors, to reduce the damaging factor, to reduce and manage the damaging factors. For the reasons noted above, we do not consider it essential now to continue with this petition, and hence we close it. The state shall, however, endeavor to have a committee so constituted at the earliest, so that the concern of the petitioner does not remain unaddressed. All right, thank you.
I am deeply obliged.
Right. How many other matters? Excellent.
Item 28.
Not 30, 40 or 30.
I could file the affidavit today only. I have extra.
You are appearing in item number 38.
38.
38.
Yes, for the.
Have you got a copy in advance to him?
I have given.
Today in the course,
I
they have
have-
given me.
Go
I
through the
would like to
copy.
file my response,
through-
your lordship. At the same time, your lordship, they have admitted that they have started.
Would you like to see the response affidavit, or would you like to argue? Tell me one thing.
No, I will file a response to it. At the
See,
same time, they may be
The
directed
Land
to.
Council for the state is calling item number 30. Land Council for the state submits that the response affidavit has been filed only today. To stop. The Land Council for the petitioner seeks some time to go through the same and file rejoinder in case it is so deemed necessary. Let this matter come up for consideration on your date of 2 weeks.
Yes, 13:8.
Your lordship, at the same time, they may be directed to produce the relevant record, your lordship.
आप पहले उसको देखिए, first see that,
I have gone through
and
it.
then if you find it to be deficient in any respect, we will take it up.
Yes. They have stated as per estimate and.
Good for you. Why do you want the other side to complete the affidavit? We will question them on that.
It will go on, your lordship.
No, it's-
After 4
yeah,
years.
Anyway, we'll see.
Oblige, your lordship.
Item 42.54.
Lordship, this matters relate to disability element of pension. So far as
We'll be required to hear it on Sunday.
Lordship, most of the cases, lordship.
Notice is not issued in all cases.
Notice is not.
That's right.
Item number 42, notice is yet to be issued, maybe issued today, lordship.
Item number 42.
42, notice is not yet issued.
इसको लिख देना. Yeah, the matter taken. Notices will go on steps taken.
And what about this 43, 44 to 48? None, no.
You know,
and-
this is notice and there is a stay, lordship.
I
Service
understand,
is
but-
complete in few of the cases.
We'll see up to the
Each and every file.
Yes.
4 weeks. We are placing it after 4 weeks.
One metal left.
Then
Any other matter left? No, sir, fix another date.
Yes, my lord, we have a PIL regarding that, my lord, pushback and deportation, my lord, some persons are missing. My lord, can it be taken up on Wednesday night? They have.
That's the matter which is here today.
Yes, yes, today.
Tomorrow, इसको pass over tomorrow. Wednesday.
Lord, they have
All right,
filed
Wednesday.
small. In item number 56, there is an interim order, lord. My lord,
It continues only till today.
yes, till next returnable, and it has been listed today, lord.
Doesn't matter. It continues till the next date. Next date means till the time the court takes it up.
My lord,